With your lordship, I beg to mention for listing of a read petition for motion, my lord, tomorrow, my lord, contractual matter, my lord.
What is the urgency?
My lord, they have earlier petitioner participated, my lord. They have cancelled, my lord. They have again retendered, my lord. That I have challenged, my lord. Tomorrow, my lord.
What is the last date for new?
My lord, last date is already over, my lord.
Retender?
My lord.
Retender, what is the last date?
Retender, that is also passed, my lord. 2nd of
Okay.
February also. My lord.
May I please? On behalf of Learned Senior Counsel MS Bidat, I beg to mention item number 6. Our health condition is not well. Kindly matter may adjourn order day. Item number 6.
Item number 6. Whose health condition?
Not well. Today he has check-up, my lord. He has been suffering from burning.
Who?
Bidat, MS Bidat.
Okay. You are Mr.
TLE.
TLE. You have informed the other side?
Yes, my lord.
Mention this. Okay. Mr. TLE, Learned Counsel. For the petitioners has made a prayer for adjournment on the ground of indisposition of Ms. B. Dr. Learned Senior Counsel. Who? Learned Senior Counsel for the petitioner. It is submitted that consent has been taken from the Learned Counsel for the respondents to make their prayer. And the mention memo to that effect has also been circulated yesterday. So in view of the ground cited for adjournment, the prayer is allowed to is the case after 2 weeks on a day to the office.
Lordship, Malad, in respect of item number 1, in respect of item number 1, Malad.
Item number 1.
Item number 1. Malad, I have also requested my learned senior, Malad. Malad, can I be accommodated on Saturday, Malad? On Saturday.
Saturday, no, I'm not inclined. Some other day.
Today, I have some difficulty today, Malad.
Okay. Any day in the coming weeks.
Lordship.
When do you want?
10th, Malad.
Given us, partner. No? Say no? Constraint the rotary constraint. Goes by rotary door. Sort of noise. Key noise. 24th March.
24th, my lord. Another case is fixed on that date, my lord, on partnered matter.
26th.
Correct, my lord. I'll manage that.
26th.
24th.
24th.
Let it be on 26th, Malad. 26th, Malad. 26th.
Okay. Mr. S. Dr. Learned Senior Counsel for the petition is present. Mr. D. Nath, Learned Counsel for the respondent. Respondent has made a prayer for adjournment and to list the case and has sought listing of the case on so and so. The prayer is agreed to by Mr. S. Dr. to stop. List the case accordingly on which date?
25th, Malad. 25th, Malad.
25th.
5th.
It will be motion days.
Or 26th, Malad.
26.
6th, Malad. Lordship.
I please your lordship. I beg to mention for listing one contempt matter, lordship, for Monday, lordship.
Give it to the court master.
Deeply obliged.
May I please your lordship? I beg to mention for listing of a writ petition for motion.
For motion.
Yes, Lord.
Motion.
Yes, lordship.
What is the subject?
Petitioner's names has been removed from the voter list.
Remove from the voter list.
Yes,
Okay. Next week. Give it to the court.
May I please your lordship? I beg to mention for listing of this matter is pertaining to the APDCL. I have been denied the electricity connection for the last 6 months.
Motion.
Okay,
give it to the court master.
May I please-
Monday or Wednesday. According.
My lord, with the consent of petitioner, I beg to mention item number 3, my lord.
Item number 3. Yes.
The counsel for the respondent APDCL has some personal difficulty with the one who is conducting the matter, my lord. Mr. B. Chaudhary.
Mr.
B. Chaudhary has some personal difficulty to the my lord.
Okay, you have informed the other side.
Yes, I have informed my lord.
Mr.
B. Das.
B. Das.
Yes, my lord.
Learned Counsel on behalf of Mr. B. Chaudhary, Learned Standing Counsel. Standing Counsel.
Yes, my lord.
APDCL.
Yes, my lord.
Okay, has made a prayer for adjournment, come on with the consent of the Learned Counsel for the petitioner. First of, as paid for Release the case after how much?
2 weeks, my
2
lord.
weeks, immediately fixed by the office.
Obliged, my lord.
Item number
May it please. This is in fact the second round, my lord.
Huh.
I'll
Forest,
forest
Forest.
of the amendment.
Let them come.
I'll get hold of. Yes,
Ah.
Your Honor.
Yes.
Yes. My lord, this is the second round, my lord. I'll attempt to state the background as I take your lordship through the annexures, my lord. First, if your lordship has page 44, my lord. This is pertaining to settlement of a stone quarry, my lord, at Tokrabandha. Now, this was the e-auction notice at page 44, my lord. This was in the month of November in 2021, my lord. 11th of November 21, my lord. This pertains to the concession area is Tokrabandha Hillstone Quarry, my lord. Now, I participated in this, my lord. I emerged as successful and I was issued an LOI, my lord, a provisional LOI. Before I take your lordship to that, my lord, one tender condition which is relevant perhaps, if I may just point out, at page 60, my lord.
60.
60.
Hmm.
Clause 10.2, my lord. The preferred bidder shall be considered to be the successful bidder upon A, continuing to be in compliance with all the terms and conditions of eligibility, B, payment of second installment of bid security and 1 month advance rent, so and so. C, this is relevant, my lord, having obtained the mining plan as per rules and its amendments within a period of 45 days of the issue of LOI. D, having obtained environmental clearance, EMP, etc., wherever applicable, as having as per instructions of Government of India, so and so. E, having obtained other applicable clearances. Now, there's an explanation to that condition, my lord. Ordinarily, such clearances under clause C, D, E above shall be taken before the bidding process by the state government competent authority. If such clearances under clause C, D, and E above have been taken before the e-auction by the state government competent authority department, then cost incurred in obtaining such clearances shall be reimbursed by the successful oblique preferred bidder, and the clearances shall be transferred to the successful preferred bidder within this period of 45 days. Such costs incurred in obtaining clearances may be mentioned in the information memorandum contained in Schedule A. Further, such time period of 45 days can be extended by the competent authority if the competent authority is convinced that such a delay is not caused on the part of the preferred bidder. However, such time extension shall be limited by Rule 17, 22, 24 of the rules as the case may be. So these clearances are mandatory. The tender says that ordinarily these will be procured before the bidding process by the department concerned, my lord. Now, moving on, my lord, if your lordship now has page 93, my lord. I emerged successful, my lord, and they issued me a provisional LOI. This is dated 9/3/22, my lord. Whereas a competitive bidding process was initiated with issuance of NIT number so-and-so by you for grant of mineral concession to extract 5 lakh CUM stone for 5 years from Tokrabandha Hillstone Quarry in Tokrabandha PRF. The stage H live auction conducted for settlement of Tokrabandha Hillstone Quarry culminated at 3:05 p.m. at 23/12/21 with the emergence of Babulnath, that is the petitioner, as the highest bidder with his offered price of so-and-so. I am directed to inform you that the following tender has been provisionally selected as per user agency for operation of scheduled area shown against their name subject to forest clearance under Forest Conservation Act so-and-so and the Assam Minor Mineral Concession Rules 2013. Therefore, you are requested to issue a provisional LOI to Babulnath being the second highest bidder and ask the highest bidder to submit the following documents. Those are the very same documents which are figuring in 10.2, my lord. So in our case, these clearances were not procured before the bidding process, and instead I was asked to procure them, my lord. Now, the process otherwise involves the role of the department also, because they have to write to the DGM to get the mining plan, etc. My lord, this process continued, and I must point out, my lord, in the midst there was some blame game where they said that I have delayed. Then I wrote back. Those letters are at page 107 and 108. 107, at one point of time, they did write to me saying that I should get those clearances at the earliest. And I was asked to submit them at the last paragraph, your lordship will find. Therefore, you are asked to furnish the required mandatory documents within a period of 180 days, counted from the date of commencement of the letter cited under reference, which will be completed on so-and-so, else MCA will attract as per 3820 under AMC rules 2013 for revocation, as well as security amount deposited for the purpose shall be forfeited to the government, please note. Then I responded, my lord, on the following page at 108, my lord. The second paragraph, if your lordship has apologize for the quality, my lord. Second paragraph, my lord. In this regard, I would like to bring your kind notice regarding minimum time frame required for the process of environmental clearance. As per EIA notification 2006, the process of EIA usually lasts for more than 210 days, depending upon program and plan involvement. So I notify them about the various stages. Then further to inform you that you have issued a letter for mining plan to DGM Geological and Mining Department on 25/4/22. RQP Abhijit Bora submitted field investigation stone sample to DGM so-and-so on 10/5/22. Petrographic analysis report received on 25/4/22. Mining plan submitted by RQP so-and-so on 14/6/22. Hence, till date, we have not received the approved mining plan. So I bring it to their notice that first of all, EIA clearance itself requires a process which will consume more than 210 days. And secondly, insofar as the mining plan is concerned, the letters from the forest department had gone late, which is why the delay, my lord. My lord, be that as it may, my lord, this process continued, my lord, and eventually at page 109, your lordship will find the mining plan was approved, my lord.
Yes.
So this is by the director DGM to the DFO, and in exercise of powers of so-and-so, it was approved, my lord. So is the case with environmental clearance, that is at page 216, my lord. The environmental clearance was also granted. Of course, there were terms of references, 216.
Yes.
Now, my lord, so this process of obtaining the clearances, though the timelines could not be met, my lord, was on the verge of completion, my lord. At that juncture, my lord, at page 225, your lordship will find a letter by an MLA to the minister concerned.
Yes.
This is dated 2/1/23. Otherwise, all clearances were almost covered, my lord. We had obtained all of them. At that juncture, my lord, 2/1/23, this is the letter by the MLA to the minister, my lord. Understanding that the highest bidder of Tokrabandha Hillstone Quarry under Dhubri Forest Division has failed to fulfill the terms and conditions of the letter of intent, kindly take necessary action for revocation of the settlement process and to publish NIT for resale, as I have a supporter who can run the Mahal. Now, thereafter, my lord, perhaps based on this, we do not know, my lord, at page 227, the Chief Conservator of Forests writes to the DFO. This is dated 21/1/23. Now, this reads as, with reference to the above, on the scrutiny of the documents report submitted by you by letter under reference, it is observed that the provisional LOI holder Sri Babulnath has violated Rule 37(3) and 5 and Rule 22(1) and 2 of the Assam Minor Mineral Concession Rules in respect of Tokrabandha, so-and-so. Therefore, I am directed to ask you to revoke the LOI issued to Babulnath in respect of the Tokrabandha Hillstone Quarry in so-and-so, by your office order number so-and-so, as per rule number 3733 and Roman 5 and 22(1) and 2 of the Assam Minor Mineral Concession Rules, and forfeit the initial bid security to the government. Further action is to be initiated as per 37(3) Roman 5 and 6 of the minor mineral concession rules to recover the unpaid balance of 15% with interest as areas of land revenue and take action as per rule. Now, although, and this was an appellable order to the conservator of forest, but since it was at the dictate of the CCF itself, we preferred a writ petition directly, challenging not just the impugned action, but also Rule 37. But however, we abandoned that challenge. At page 281, your lordship will find the order that was passed, in that writ petition. There was an undertaking by the learned additional advocate general that there may not be any order need to pass any stay order, inasmuch the authorities will not proceed with the retender.
Why it was before division bench?
Because we had challenged Rule 37, but later on we withdrew that challenge and confined our challenge only to that order of 27/123. So it was sent back to the single bench. Now, my lord, when this process, when the proceedings were pending before this court, my lord, the forest authorities reached out. We also had a talk, my lord, and there was some sort of an understanding that we will conciliate as to how to resolve the issue, because ultimately mining plan, etc., were not in my hands. So the delay essentially occurred because of the procedural steps, my lord. So at page 282, my lord, my lord, I am made to sign, the petitioner is made to sign an undertaking, my lord. Now, this undertaking, if I may just read two of the clauses, my lord. The first one at the top. I hereby agree to withdraw case number so-and-so filed by me against the state of Assam and its authorities in respect of the cancellation of the settlement order for Tokrabandha Hillstone Quarry within 30 days. I shall not raise any further claim in dispute in this regard before any court, tribunal, or forum. The third point is important. If competent department reviews or reconsiders the revocation order, I undertake to fully comply with all terms and conditions that may be imposed by the concerned authority. This sort of gives us an indication, the representation that was made. On the following page, my lord, at page 283, the lordship finds another letter, this time by the forest department to the petitioner concerned. It says, it reads as, with reference to the subject cited above, you are requested to submit details of withdrawal of case number so-and-so against the state of Assam and its authorities to this end as soon as possible. So this gives us an indication there's some sort of an understanding or negotiation going on. Now, this is also recorded in a judicial order passed in that writ petition that your lordship finds at page 285, the relevant portion. Lord, second paragraph onwards. After hearing the parties at some length, the learned counsel for the parties have submitted that there may be possibility of conciliation if the parties are granted liberty for the same. In view of the submissions made by the learned counsel for the parties, list this matter again after 3 weeks on the date to be fixed by the registry, so as to enable the parties to attend the conciliation on the issue raised. Interim order passed earlier shall continue till the next date of hearing. Now, in terms of that demand, at page 282, your lordship will find we eventually withdraw the writ. However, two liberties were reserved for us. Paragraph 2 of that order at page 288, my lord. On the last occasion, this court had observed that the parties were consenting to attempt a conciliation proceeding. Today, learned counsel for the parties submit that the parties have arrived at an arrangement and therefore the petitioner would not like to pursue the matter in its present form. She accordingly prays for leave to withdraw this writ petition in the present form with the liberty to approach again in case of violation of any of the terms of the agreement. At the consensus of the parties, this writ petition is closed. Since the learned counsel for the parties have made a submission that the parties have arrived at the conciliation, liberty is granted to the petitioner to approach this court again in case the matter is not settled as per the terms of conciliation. Now, our specific stand is, my lord, after this happened, we were not even invited. Nothing, no formal order, conciliation award or speaking order was passed. And straight away at page 290, your lordship will find a fresh long e-auction notice is issued. On 12/2/23, the bids are supposed to be open day after tomorrow.
Apna whole.
I'll just, that's okay.
My lord, as per I can recall, I don't have the copy, these actions of the authorities, my lords, because the legal fiction was there, my lords. Because there were definite time period that in which he has to submit those additional amounts, my lords, the agreed amounts. So this cancellation was done on basis because he was found in violation of certain rules. Rules 37, 3 of some minor rules and rule 22(1) and 2,
Those are referred in the order.
my lords.
Those are
So,
referred in
yes,
the
my lord,
order.
yes, my lord.
Cancellation order.
Yes, my lord.
Revocation order.
Yes, my lord, because lordship.
Then for what purpose?
If
you
those rules have to
decided
look.
to
My lord.
enter into some conciliation.
Yes, madam, but since our instructions are there, that it was found dehorsed the rules, madam. Though we tried to arrive at something, but my lord, it was found out that legal fiction has occurred and the
But till
rules,
December, you are arrived at an agreement.
my lords,
It is recorded in a judicial order. till
recorded, madam. Yes,
December-
recorded.
December two,
But
page
my lord,
288.
that indicates only an attempt. It doesn't indicate that, it doesn't demonstrate that that it only
288.
goes to the attempt.
288.
288.
Attempt was on,
Both,
attempt was on 28/10/2025, page 285.
Yes, my lords.
285, second paragraph. Right?
Yes, my lord.
Then 288. Second paragraph, second line. Today,
My lord.
288.
288, I'm going through, my lord.
Second paragraph, second line.
Today, my lord, yes, my lord.
Yes. Have arrived at an arrangement. So something has been crystallized. If my understanding of this line is correct.
But the major chunk of that that paragraph, my lord, 80% has come from the practitioner's side.
Whatever, I don't know.
My lord,
You should have reviewed it. That no, still in the process of arriving at an
Yes, my lord.
arrangement. Still in the process of arriving at an arrangement. Here you have said they have arrived at an arrangement.
So it's, my lord, indicates our presence.
Yes,
the-
yes, it is an inter-party order.
My lords, but this paragraph is read as a whole, my lord, it doesn't inspire that thing that something has come from us,
Otherwise, his money has been blocked.
my lords.
I think he has deposited some money.
Some money because
How a businessman wants to keep the money blocked without any positive
my lords.
indication from the respondent authority.
My lord, his money was not commenting on his claim now. His money was liable to be forfeited because there was a violation of certain rules. Because legal fiction occurred and he was found, though he submitted
Materials
some,
on record do not suggest that.
my lords. No, that is
Do
the
not
reason, my
suggest
lord,
that.
my lord, if the lordship looks to
Your
be,
correspondence, whether the DFO is writing on his own,
my lords. Well, if my
Then-
lords goes to
then he should have said that, yes, continue with your challenge. We are ready to face it.
my lords.
That is
Well,
not the
initially,
intent.
because my lord,
Don't-
legal fiction was invoked
Legal
and,
fiction was at the time of revocation.
yes, my lords.
He challenged it.
He challenged the rule itself,
I challenged the rule itself.
my lords.
Right. Then thereafter, it was relegated to a single bench.
My lords.
Right. He had forgone the challenge to Rule 37.
Rule 37.
Right. Thereafter, he gave an undertaking. And DFO also wrote it back.
My lords.
For what? That he will forfeit.
Forfeit, my lords. Any claim.
Forfeit. So, he is ready to forfeit his money. Is it the indication? He giving the undertaking that, okay,
What is that?
I'll forfeit all my money. All beach security.
282, no?
You should have said that, no, we are not into any settlement or process of arriving at any settlement. Yes, had it been said that yes, it
Settlement.
is for the
of
purpose of not forfeiting his money. Okay, we'll allow him to go unscathed. That is not the case.
No, my lord.
Heard.
My lords, we'll fix it tomorrow, my lords. Because this.
But I have heard
No, my lords.
for
my
half
lords-
an hour.
No, my lord has to fix it tomorrow because my lords, honestly, one thing, my lord, see, the price was offered at that time. It
today-
is escalated now, my lord.
I have less cases.
My lord, I will know.
Tomorrow I have many cases.
My lord, I have,
Heard, Mr.
my lord, I have to take
Director.
instructions, my lord, and the fate of this tender, my lord. Because the price of the mineral also is also essential, my lord, because the price offered then, that time, might have increased now also, now, my lord. So looking at those aspects, my lord, we'll fix it
Mr.
tomorrow. I can
Gogoi,
try to
when
bring
it
some.
was filed, the copy when it was given. You should
I
have
have no-
armed with all the instructions.
My lord, I don't have the copy, I didn't reveal those things. I took the second copy.
How can it be listed without serving a copy?
No, I'm not disputing. They have some, might have served, my lord. I'm not disputing, my lord. I'm not disputing it. My lord, kindly keep it tomorrow, my lord.
How can it be? I have heard tomorrow.
I understand, my lord,
half an
that,
hour,
my lord, the
I have
process, if the process, my lord,
20
is,
motions listed tomorrow.
then Monday, my lord.
No, no. I have heard.
No, my lord, because I have to
Get the-
still,
I'll put it, if the respondent wants to make any application for they
My
are
lord?
at liberty
my lord,
for vacation of the order.
my lord, that will again
Heard.
drag
Mr.
this, my lord,
DT.
because
Yeah.
when there's a tender process, it's been, this Mohol has been state for such a long time.
As on that, I am prima facie satisfied that you started a process
My,
of
my lord,
conciliation, then made a submission,
my lord.
and every indication goes that you want to revive the process with a petitioner.
My lord,
Somehow or other, whatever. And I don't know what is your arrangement, which is not placed on record, but before the court, it has been submitted that they have arrived at a settlement.
lordship will take it a bit too, my lords. Take it a bit too, my
No,
lords.
no, we will.
Well, I
we
can
have
have,
some other matters
because my
to
lord,
have
this
period
process is stopped, my lords.
petitioner.
If this process is stopped, my lords,
We do not go.
because my lord,
for
this
hearing it.
MCC is also coming, my lords.
What MCC?
Model code of conduct will also be there, my lords. We want to
Huh.
finish it up, my lords.
And Mr.
Hmm?
E. Google. Land study of Forest Department.
I'll pray, honorable my lords, to fix it
Mr.
tomorrow. my
Google, you
lords.
should have said it at 10:30.
My lords,
I would have happily
I was on legs and,
adjourned. I would have happily adjourned the
my
matter.
lords. I was on legs at 2, my lords, at court 2. I just came
You
running
have,
out.
you have,
I,
Mr. Gugoi, I think Forest Department has a set of how many turning outs? At
that I
least
would like to, that I don't
can
want to.
visualize 5, 6,
5, 6, my lord, but
minimum 5, 6.
the only deficiency on a difficulty, this copy was not yes.
This is not proper.
I understand, my lord.
Just refresh my friend's memory, Manoj. In fact, we did not know at that relevant point of time that the settlement was going on. So we argued on merit. Midway, my lord, Forest Department came and said that the settlement is on, which is why it was adjourned. In fact, I shouldn't say this, my lord, the court actually found favor with her case that day. My lord. Thereafter, that proposition
No,
was made.
till then I didn't argue.
I was not
Till then I
peeping
didn't argue, my
deliberation,
lord.
So we'll not
My
comment
lord,
on
I'm
it.
just
But indication goes that
goes, my lord.
you should have said it. You should have sent some person.
R.R. Gogoi was there. He was also not very thorough to this matter.
10:30 also. Mr. Gogoi was there.
Yes, man. He
At
he
10:30.
was just my replacement. I was in court 2. I came and he rushed back.
Please. If you were not ready, you should have interrupted him. I was hearing,
I'm
and you
sorry.
were also hearing his submission. Okay, after something. Go through after something.
My lords. Obliged.
But this is not
I understand,
appreciated.
my lords, but sometimes it happens, my lords.
This is not appreciated.
My lords. I apologize, my lords.
Item number 2.
May it please your lordship.
Hmm.
In this
What is your matter? Service. Oh, 2 and 3. 2 and 2 and 3. Enabling check. For withdrawal.
Good. Good.
Yes, you appear for whom?
Loss in the cause list, so the higher education loss. Basically, I don't know party, actually school education, I think it's elementary education loss. But one Assam loss.
Higher education.
Loss, high is not the party loss. Actually, it's a school
Who is the
education.
party?
School education loss. School is represent, I think, by elementary education.
So higher education to represent school education.
School education loss.
Education department.
Lots of school education.
When the matter was moved, my lord.
Further, and what about trustee?
Justice, sir. We filed the affidavit. At page 42, my lord, the seal is there. Of the affidavit.
What kind of organization is this? Adarsh Bidyalaya Sangharsh?
My lord, this, if lordship takes up
Where is the NIT?
my lordships,
Where is the NIT?
at page 12, initially when we had filed the writ petition, my lord, we had indicated higher education department. However, my lord was pleased to allow correction to the education department per se, not higher, middle, lower.
Okay, you represent whom?
No, I am because the
You represent whom?
lordship. Because I'm higher education lordship.
You are higher education.
Higher education lordship.
Okay, call somebody from
Lots of-
education department.
M. Soikia was representing last.
You are school education department.
Lordship, I am for the elementary education. This matter.
I don't know. I
Elementary.
don't take bench to matter.
Okay, my lord. My lord,
I have not been given bench to matter, so I don't know.
So this has nothing to do with the, this part.
Who is the proper department?
Then lordship. Proper department.
Property Department Lordship takes up the order, my lord.
Was this
Order so 17/11/2025 order passed by this court. Last order.
Oh, acha.
May I read, my lord? Paragraph number 2.
So among them, let
Oh,
them
sorry,
resolve among themselves who will
Yes.
represent. That is what my question is.
Acha, it's the elementary education, but unfortunately, my lord, the elementary education in the cause list, the name
Okay.
has not been reflected.
Okay. So an affidavit from the education department is necessary,
Necessary.
right?
I have come to know.
Now,
Just now I've been informed.
Bhuya has said he is from education department.
Higher man.
Higher education department, so he will not represent
The
the respondent
concerned-
number one. So you represent,
I will represent.
right? And you file the affidavit.
I'll file my affidavit.
In the meantime, interim order will continue.
File. If there is, my lord. There is. My lord, I may be given a copy also, my lord.
Okay. Heard Mr. S. Bonik, learned counsel for the petitioner. First of Mr. S. Bhuya, learned standing counsel higher education department, has submitted that in the cause list, the name of higher education department is reflected. However, the subject matter of the petition pertains to elementary education,
Elementary, man.
elementary education department. And
As per
therefore,
order dated 17/11/25.
he will not represent the respondent number one. First of, para Mr. A. Fukan learned standing counsel, elementary education department, who is present in the court, has submitted that henceforth he would represent the respondent number one.
One.
Post of para earlier, earlier on 9/2/2026. 2 weeks time was granted the respondent number one to file the counter affidavit. Post of. In view of appearance of the learned standing counsel, elementary education department today, further 2 weeks time is granted to the respondent one to file the counter affidavit. Post of. Para, the petitioner submitted an affidavit as regards service of notice upon the respondent number 2 and 3 by way of justice. So the matter is to be placed before the Lajima court to make a report as regards service of notice upon the respondent number 2 and 3. So lays the case on so and so. The interim order passed earlier shall continue till the next.
My lord, the registry to reflect.
The name of the land standing council.
Fine.
Elementary education
Elementary.
department is to be reflected in the respondent side in the council. And
Deeply
your name also?
My lord, no. My lord, name is not required. Name not.
Because another person will come
No, my lord
on
can
the
reflect.
next
Also.
date.
My lord can reflect.
That is happening.
Deeply obliged.
Okay, name of Mr. A. Fuka.
Fine.
Land standing council.
To be fair and honest, my lord, education department would not have much of a say. It's the private respondents who floated this thing, although under the department. Department has nothing to do with it, basically. It has nothing to do with it. The only thing was 2 clauses.
So what are the
They're under the education department.
what kind of organization it is?
These are organizations under the state department, state. So
State department.
State
So
department.
definitely they
They
may
control-
represent.
I don't know. Sir.
And they
I'll get my
can make
instructions.
yes,
respondent number 2 and 3 to appear.
yes,
It is up to them.
up to them. Obliged.
Obliged.
On man has appeared to represent represent the respondent number 2 and 3.
2 and 3.
To the
Deeply.
মাজত লিখি দিব।
Please, your lordship.
Yes.
Lordship, the petition was given a work order. Lordship,
Uh-huh.
the petitioner was given a work order for construction of a toilet. The work order is at page 29, Annexure 3.
29.
11% at page 30. Work order number, work order value, and it is given to the petitioner BK Construction.
1 minute. So it has schedule of rates.
Lordship.
These are works or rates?
These are BOQ. Technically, if I
Yes.
say it is BOQ.
Okay.
Lordship, the work was done to the full satisfaction of the department and by the annexure for.
What is the work value?
It was of 25 lakh 41,000.
Huh?
25 lakh 41,000. Page 30, Lord.
Yes, 30.
Page 0. Work order value
Work order value.
in the box, left hand side.
25 lakh. 25 lakh. Okay.
Annexure 4 is the completion certificate. Page 49. Relevant is page 50.
What is the work order date?
Work order was dated 15/7/22.
7. Date of commencement. Date of actual completion.
Certificate work has been completed
Date
as
of
per drawing and
CDD.
specification.
Date of C. Okay.
Lordship, thereafter, at page 63, after 3 years, I was given a so cause notice. Annexure 6, page 63.
Hmm.
Where you did you have?
Yes.
Lordship, para 3, para 2, PO was purchased, placed on so and so, and the job was completed on so and so. Work order amount was rupees 25 lakh 41,000, and the total payment made against
You
the.
mean same thing, work order.
Yes, purchase order, Lordship.
Work order, purchase order,
Same thing.
same
One
outcome.
and the same thing.
Yes.
And the total payment made against the job was rupees 25 lakh 34,000. However, during a recent verification, inspection of the quantities executed under this job, it has been observed that certain additional items not covered under the original PO were executed. This has resulted in the excess payment of rupees 3,23,404.80. And I was given a show cause under a holiday listing guidelines dated 19/1/2023.
Let us read
Yes,
fully.
fully, yes. The vendor bear a critical responsibility in ensuring the accuracy and integrity of the final measurement sheet submitted for billing purpose. As per standard practice, final measurements are to be jointly recorded in the presence of both the plant's authorized personnel and vendor's representative. By participating in this process, the vendor implicitly certifies that the quantities recorded are true and reflective of the physical work completed on site. Any deviation, inflation, or misrepresentation in these measurements, whether by omission or deliberate action, constitute a breach of contractual obligation. It is also worth mentioning that you are fully accountable for verifying and endorsing the correctness of the measurement sheet prior to bill submission, and any discrepancies discovered post-payment may be constituted as evidence of fraudulent intent or gross negligence. In respect of the aforementioned work, you have prepared the incorrect joint measurement sheet, knowing fully well that it does not commensurate with the physical work done. You had also signed it and did not bring it to the notice to the corporation when amount exceeding the actual work done was paid to you. It can be inferred from the above that you have deliberately prepared and signed the incorrect measurement sheet with a dishonest intention for causing wrongful financial loss to the corporation and wrongful gain to you. It may be noted that the corporation has also issued holiday listing guidelines dated so and so. The relevant clauses of the policy are mentioned herein under. Reasons for putting a party on holiday: if a party has indulged in malpractices such as bribery, corruption, fraud, pilferage, bid rigging, price rigging, injury to reputations or property of the corporations, in acting dishonestly, causing wrongful financial loss to the corporation or wrongful gain to the party. In view of the aforementioned irregularities, you are required to show cause in writing within 15 days from the date hereof why you be not placed on the holiday list and be debarred from entering into any contract with IOC, be not delisted from the list of approved vendors, contractor of IOC. Your reply should be supported by all documents and documentary evidence which you wish to rely in support of your reply. Should you fail to reply to this so cause notice within the time and manner aforesaid, it will be presumed that you have nothing to say and we shall proceed accordingly. Your reply, if any, and the documentary evidence given in support shall be taken into consideration prior to arriving at a decision. You are also requested to provide the detail of firm's agency company where you are a proprietor or partner, or you are a partner. The aforesaid is issued without prejudice to the rights of the corporation under the contract or applicable law.
You submitted a reply.
Yes, Lordship. Annexure 7. Page 65. May I read it? Proceed. Para 1. At the outset, it is respectfully submitted that the contract was a work contract and not a supply contract. The entire scope of work was physically executed on site under the continuous supervision of IOCL authorized officials. The result of the work continues to exist at the LPG bottling plant, Dimapur, and may be verified at any time. The construction stands completed in full functionality and in accordance with the operational requirement of IOCL. The existence and performance of the work itself disprove any claim of over measurement or irregularity. The work was carried out strictly as per drawing specification and instruction issued by IOCL engineer. However, as is common in civil execution, the actual site condition often reveal technical variations or practical discrepancies between the paper drawing and on-ground realities. In such circumstances, modifications or additional work become necessary for the structural soundness and functional viability of the project. In the instant case, several such adjustments were executed. only on the verbal and on-site direction of IOCL authorized officer present at site. In particular, during the course of execution, it was observed that initially proposed layout required a septic tank of higher capacity to ensure the long-term functional adequacy of the toilet and washroom facility. The said additional structure was built on the express verbal instruction of IOCL authorities during progress of the work. This item was essential for completion and was executed solely in the interest of the corporation, not for any additional profit or benefit to the contractor. It is pertinent to highlight that no payment has been made to us for this additional work till date, even though it was carried out in good faith in IOCL behalf on the assurance of issuing additional work order. It is therefore wholly unjustified to allege that our firm has claimed or received any excess payment. On the contrary, the record reflects that all measurements were jointly taken, verified and signed by IOCL site representatives and our authorized personnel before submission of any bill. Every bill was duly checked, approved, certified by IOCL officials before release of payment. Hence, the suggestion that any incorrect measurement sheet was prepared or signed deliberately is factually incorrect and defamatory in nature. If IOCL's internal verification has now revealed a variance, the same can only be attributed to technical interpretations differences, side level adjustment or variations in drawing to execution correlation, none of which can constitute misconduct or fraud. As this work was a work contract involving measurable construction, not a supply contract of quantifiable items, the measurement inherently depend on site-specific variable. It is both inequitable and contrary to industry practice to retrospectively treat such genuine technical variation as over measurement or wrongful gain. Moreover, from your own admission, certain additional work were carried out, and you must distinguish between the situation where measurement are done for no actual work being carried out and measurement of additional work actually carried out. Furthermore, the work was completed on 7/12/2022 and the defect liability period expired long back without any complaint, objections or adverse remark from IOCL. It is incomprehensible how after nearly 3 years of satisfactory completion and use of the facility, a claim of overpayment could be raised. Such retrospective action is arbitrary, violative of contractual timelines, and contrary to the principle of natural justice. Any such claim at this stage is legally untenable and administratively improper. It is reiterated that our firm has been a trusted and long-standing contractor of IOCL for over 2 decades, having executed numerous projects exceeding 100 crores in total value across various IOCL locations to the corporation's satisfaction. Our reputation and working relationship with IOCL have always been based on honesty, quality, and compliance. Issuing a show cause notice alleging misconduct without proper opportunity for clarification undermine the mutual trust and adversely affect the morale of dedicated contractor who has served the corporation with consistency and reliability. We categorically deny any allegations of dishonesty, fraud, or intent to cause wrongful financial gain. All actions were undertaken transparently in good faith and under IOCL supervision. The tone and implications of misconduct in the notice are unfounded and defamatory. To resolve any perceived discrepancy, we request a joint re-verification of the site and record in the presence of IOCL technical officials and our representative. Such a transparent exercise will conclusively stabilize the accuracy of the executed work and measurement. We also object to the proposed reference to the holiday listing guideline dated so-and-so, as the same has no relevance in the present context. The present issue does not involve any act of corruption, malpractice, fraud, or moral lapse. Invoking such provisions against a bona fide contractor for a technical variation will amount to misuse of discretionary power and will cause irreparable reputational damage to our firm. In view of above, we respectfully request that IOCL immediately furnish the complete set of document, record, verification notes, and computation sheet relied upon for alleging the excess payment. A joint physical verifications of the site and executed work be undertaken in the presence of IOCL's competent engineer and our representative to determine the actual executed quantities. IOCL acknowledge and regularize the additional work, including the construction of septic tank and related site modifications, which were executed under direct verbal and on-site instruction of IOCL's authorized officer. These items were essential for ensuring a functional completion and longevity of the facility and were executed solely in the corporation's interest without any ulterior motive or financial advantage to the contractor. The so-cause notice any proposed holiday listing action be withdrawn forthwith, as the allegations contained therein are false, defamatory, and tending to damage the hard-earned professional reputation, goodwill, credibility of our firm, which has been a trusted partner of IOCL for over 2 decades. Should IOCL fail to withdraw these unfounded allegations or refrain from making any further defamatory imputations, please take notice that our firm reserves its absolute right to initiate appropriate civil and criminal proceeding under law. We affirm that every act on our part was performed in good faith under IOCL supervision and in the corporation's best interest. The construction stands as visible proof of work duly completed to IOCL's satisfaction and functionality. We therefore urge IOCL to close the matter immediately in the spirit of fairness, transparency, and the long-standing relationship between the corporation and our firm.
Where is the so-called notice?
So-cause notice, Lordship, at page 29, 63, sorry, Lordship, 63.
So in the so-called notice, it referred to a clause of holiday listing guidelines dated 19/1/2023. Right, 2.1A. So in the counter,
My lord.
you say assuming this is not, these guidelines are not applicable.
My lord,
Just a minute. Assuming these guidelines are not applicable,
my lord.
so the previous guidelines of July 2015 would be applicable, right?
Hello.
That is a slight subtle change in stand
My lord.
in the counter. Now, in your counter,
My lord.
you have annexed the July 2015 guidelines.
Hello.
Now, come to that is running page 92 perhaps.
My lord.
Which clause? Assuming that.
Hello.
All assume.
My lord.
2.1.
2.1.
Which one?
2.1A read with 2.1C.
Has indulged in malpractices such as bribery.
My lord.
Is there any allegation of bribery?
My lord, what is?
Nowhere.
No.
Nowhere. Corruption. Nowhere. What is fraud? Pilferage. Bid rigging, price rigging. It is not there.
No, no.
Fraud. What kind of fraud? Then C. Has submitted fake, false or
False.
forged certificate. Which one is?
My lord,
What is fake or false or forged?
My lord. My lord, I also try to understand the actual ground reality in the matter, my lord. The stand of the client, the IOCL, the corporation is, when a PO is issued, a purchase order is issued, it has a certain value attached to it, assuming it's 10 rupees, my lord. The 10 rupees is the outside maximum most value which is attributed to a purchase order. Now, my lord, if your lordship, if I work, if that purchase order is allotted to me, the work which I might do might not reach the level of 10 rupees.
Is the so-called notice served by the engineer in charge?
63. It is, my lord, as I understand, CGM, my lord, CJM, Amar Jyoti Bodolo, my lord, Chief General Manager,
Come to 92.
92. So that was one of our,
When 92, 93, 94.
yes, my lord.
95, 3.3. It is a works contract or purchase order?
It's a, my lord, it's a BOQ, my lord, as in, they have to justify that, whatever work has been done, my lord, yes.
Page 95.
Yes, my lord.
3.3.
Yes, my lord.
Control.
This show cause notice should be issued
Yes,
for
my lord.
works contract
Yes, my lord. By engineer in charge.
after order is accepted by the party. B, by the order issuing authority before acceptance of the order by the party. B is not applicable,
My lord.
right?
My lord.
For purchase contract, by purchase order
Order
issuing
issuing
authority.
authority.
Which one is applicable here?
My lord, it's ideally, it should be by engineer in charge after order is accepted by the party. In fact, my lord.
Because you come to completion certificate.
My lord. 49.
Page 50.
My lord.
Engineer site engineer,
My lord.
and engineer in charge, right? Page
Yes, my lord.
50.
Engineer, site engineer, senior
Both.
engineer, deputy engineer, manager, and yes.
No, those are blank.
Yes, those are blank.
One is site engineer
My lord.
and the other one is engineer in charge.
Yes, ma'am.
Right.
Yes, ma'am.
Come to page 53. Definition. 54, 1.3, 13.00.
The engineer in charge shall mean the engineer or other officer of the owner, consultant, or other organization for the time being nominated by the owner in writing to act as engineer in charge for the purpose of the contract or any specific works.
Then 53. 1.8.0.0.
Completion certificate shall mean the completion certificate issued by the engineer in charge in accordance with the provisions thereof.
Now,
My lord.
show cause notice
My lord. It ought to have been, yes, my lord. 63.
ought to have been given. This is one. Page 59, final measurement.
My lord.
Then page 60, 6.2.0.0. Before that, 6.1.5.0.
Measurements.
Measurements shall be signed, dated on each page by the contractor,
My lord.
representative and site engineer,
My lord.
right?
My lord.
Then if the contractor objects all this, then 6.2.00. Final bill on the basis of final measurement entered in the measurement books sheets by the engineer in charge upon any objection or mode of measurement decided by the engineer in charge.
My lord.
Upon any objection, the
My lord.
contractor shall prepare and submit to the engineer in charge a final bill. Only after all this clearance,
My lord.
engineer in charge, he can submit the
My
final.
lord.
Okay.
My lord.
Then show cause notice. You said certain additional works were done.
My lord. My lord.
And you referred to guidelines, then you said incorrect measurement sheet. Wrongful loss, wrongful gain. Then he replied. Then what did you do? Come to page 70. You said, first paragraph,
This is
regarding the work.
yes, my
Second paragraph, work order, purchase order,
my lord. My lord.
date of completion,
My lord.
payment.
My-
Third paragraph, recent verification.
My lord.
You now quoted an amount 3,23,404.80. Right.
My lord.
This was not mentioned in the so cause notice. Now come to your affidavit in opposition. Paragraph 6. First subpara.
My lord. Be that
Be
as
that as it may, subsequent verification by the vigilance department
my lord.
on the basis of a complaint
Yes, my lord.
carried out an inspection. So there was an existence of a complaint.
My lord.
and inspection was carried out, maybe behind the back of the petitioner. Then you observed 3,23,404. Right?
My lord.
Then page 9, or paragraph 9. A detailed inquiry was carried out by the Vigilance Department of the corporation on the basis of a complaint received by the corporation. That's the report by the Vigilance Department.
My lord.
Based on the site visit for measurement, in the presence of such Vigilance Department official of the corporation, concluded that excess amount of rupees so-and-so was done over and above the purchase order quantity.
My lord. My lord.
Then you annex the report.
Yes, my lord.
So all these are behind the back.
These,
All these are behind the back.
my lord, in the absence of.
Behind the back
Yes,
of the
yes,
petitioner,
yes,
complaint
Yes, my lord. Yes, my lord. True.
not furnished to him.
True, my lord. True, my lord.
Site visit verification
My
by
lord.
the vigilance officials.
My lord. True.
Whether they are expert or not, I don't know.
True.
Might be in absence of engineering in charge also. Then it was behind the back. Third, a report. Existence of a report. So existence of a report first, complaint.
There's a complaint.
Second,
Inspection,
site visit
Site visit.
without the presence of the petitioner.
My lord.
Third, there is a report which
Okay.
concluded 3,23,000.
Was
Right.
over and above. Yes, my lord.
These are not part of the show cause notice,
These are not part of the show. There is not admitted, man. These are not part of the show. True, man. True.
right?
True, man.
Then initially you said we'll take action on the basis of guidelines 2.1a. There is a subtle shift in your stand, assuming those are not applicable.
No.
July 2015.
Because your lordship has raised a very pertinent query on the first day when my senior was.
Because it was
True, my lord. That was, we wanted to address that also, my lord. We wanted to not leave it.
order
My lord.
or so cause notice.
My lord. It ought to carry the foundation on which
Yes.
it was based. My lord, true. My lord, I cannot dispute that, my lord. In
And-
fact, yes.
And after completion of 3 years, the work was executed when?
2022, my lord.
2022. So cause notice is of what date?
My lord, 7/10/2025, my lord.
So let us see the completion date.
The completion, page 49.
7/12/2022.
Yes.
So exactly 3 months up, 3 years.
3 years. More than 3 years. In fact, my senior
fact,
friend,
More than 3 years.
my lord, 3 years and
3 years over
Oh.
on 6/10/2020.
My lord.
Okay, let us see 3 years. 3 years. So these are the, and whether you have paid a bill. He is saying that he did not, you did not pay the bill.
No, in fact,
And so far as at the instruction,
my lord,
site engineer
My lord.
and engineer in charge.
my lord, as per the mandate, my lord,
And the final bill,
my lord,
how can, let us see once again,
my lord.
6.2.0, page 60. On the basis of the final measurements entered in the measurement book,
Book sheets.
the measurements decided by the engineer in charge. Upon any objection and or mode of measurement decided by the
Engineer in
engineer in charge. Upon any objection being the measurement to be adopted in such event, contractors shall prepare and submit to the engineer in charge a final bill
Yes,
in the prescribed format
my lord,
with reference to the total work covered by the contract.
my lord.
Such bill is to be drawn up by applying the so-and-so,
Yes,
right?
yes, ma'am.
Then 6.2.1.1, if there is any difference or dispute between the contractor and the owner as to the items of the schedule of rates applicable so-and-so, the decision of the engineer in charge on the applicable item shall be final, binding upon the contractor.
My lord,
The engineer in charge shall be of the opinion that the disputed supply so and so not covered is not covered by any item in the schedule of rates, right? The engineer in charge shall determine the applicable rates.
My lord.
And according to the provisions so and so, the rates so determined by the engineer in charge shall be final and binding.
On the contractor.
Contractor.
Yes.
Next, if the contractor has already prepared the final bill, the contractor shall amend and the final bill
My lord.
to apply the applicable rate of the schedule of rates or rates as determined by the
Yes.
engineer in charge. If the contractor has not prepared the final bill, shall prepare the final bill accordingly.
The
Then
modification
next,
for the final bill.
final bill shall, in addition to the payment entitlement, arrived at according to so and so and associated clauses, include in a separate statement annexed thereto the notified claims of the
My lord.
contractor as provided in so and so. Lastly, so this is the way.
This is the
There is a verification process at every stage.
the only flaw,
Everything escaped.
everything escaped and
You
this
just somebody recommended come to now your vigilance report, so-called vigilance report. Page 89.
My lord. We are in receipt, but I'll read, my lord. During our JSAI joint survey inspection.
Site inspection.
Yes, my lord. Yes, ma'am. At Dimapur LPG bottling plant, which was carried out in February 2023, on random checking of some POs, it was observed that excess payment was made to vendor in some works and less or nil payment was made for extra items done in that work which was not included in PO and for which deviation approval was not existing. Based on our findings, appropriate employee actions and systematic improvement measures were recommended. We have received the ATR for all except employee action against Sri So-and-so and Sri So-and-so. We are in receipt of CDA's tentative decision of recordable warning against Sri So-and-so, employee number so-and-so on 12/3/2025, against our recommendation of major penalty. Going through all documents and CDA's comments, we have decided to accept CDA's tentative decision to accord recordable warning to Sri So-and-so, employee number so-and-so in the subject case. You are requested to take the following action. 1. You are requested to record recordable warning to Sri So-and-so and submit the ATR. Submit ATR with regard to recommendation of major penalty to Sri Mintu Das, so-and-so, I apologize. You are also requested to confirm that recovery has been made from the contractors after proper reconciliation of the work. If not, you are advised to make assessment of excess payment made to the vendor and recover the amount under intimation to us. Suitable action may be taken against the contractor involved in the fraud. ATR for all of the above may be submitted to the vigilance at the earliest. My lord, there are two employee names, my lord, which have been given. The first name, my lord, Mr. Fukon, was on a contractual basis with the corporation, and the other employee, Mr. Das, my lord, the punishment of termination has been issued. But that is, again, my lord, that is something which has been done by the corporation. And I agree with your lordship that a lot of steps for verification, modification of the bill had also passed. My lord, in this regard, there are a few documents that I would like to submit before this honorable court as to what was done and why was it done, my lord, if your lordship permits me, my lord. 3, the vigilance exercise, my lord.
Look, these are not part of the document.
No, my lord. These are in fact.
These are not.
No, my lord. In fact, these are internal documents which had made, which had asked our clients to say that we'll submit it before the court if putting it before the affidavit may not be permitted.
So come to page 83.
My lord. Page 83. My lord.
Extra works, right?
Yes, my lord.
Extra works. Extra item not included in the purchase order, right?
My lord.
Item number 3.
Item number 3, my lord. Serial number.
Right.
Yes, my lord.
Now, did you make extra payment for it?
No, my lord. What is
yes or no?
Yes. Extra payment was made within the confines of the purchase order. My lord, that is what I wanted to understand from our clients as to what was the deviation which has existed. My lord, the outer.
No, I have already indicated to you.
My lord, my lord.
Right?
My lord.
If something
My lord.
is contractual breach.
True, my lord.
Then
My lord.
is it an act which calls for debarment or
My lord, that was,
huh?
there's a bona fide dispute.
He had
which is-
done his work. It is not that quality was compromised. That was not the allegation.
No,
Not the allegation. Not the allegation or defective materials were used. That
That
is not
was-
the allegation.
that is
He had
not- that
done
is not-
some extra work, but some tiles, I have seen page 83,
Yes, my lord.
some tiles, page 83 or
Page 83, my lord, the last column, my lord. The rest of it
page
is
83.
slightly technical terms, my lord.
flooring with size of tiles 60 into 60 cm in cement mortar, providing and fixing first quality ceramic glazed wall tiles,
My lord.
12 mm thick plaster,
Mm.
18 mm thick plaster. And his explanation is that septic tank and something which is required.
Yes, my lord.
And under instruction of site engineer and
Site
engineer in charge. And these two persons perhaps were the site engineers.
Yes, my lord. Yes. Yes.
Is it so?
Yes, my lord. In fact, subsequent cases, my lord, matters pertaining to the other vendors, their names feature in the final bill, my lord. M. Das, which I'm assuming it to be Mr. M. Das, which is recorded in page number 89 of the affidavit. Not now. Yes, M. Das. So his signatures existed, my lord, not in these documents, my lord, in three other similar cases which are pending before this honorable court, my lord. Plant in charge.
He is in charge.
Plant.
Site engineer
Plant manager.
or
Plant manager, lordship.
no,
Site
no.
in charge.
Huh?
Site in charge.
Site engineer. There are two
The
authorities.
two authorities, man. No, page 50. Page 50.
Come to page 48.
Yes, my lord. M. Das, my lord, plan manager.
Who is he?
Engineer in charge, my lord.
He is
Engineer in charge,
engineer in charge.
My lord.
And site engineer Velino Pego.
my lord. Yes.
Senior LPG officer Septi. So Mintu Das is plant engineer, authorized signatory. So Tokos ought to have been under his signature.
Yes. In fact, we have taken action against him.
Ah.
Taken action. In fact, what has happened, my lord, the entire mechanism which has been laid down, my lord, it is the work here. the
Breach
di-
of contractual, this thing, some contract
My lord.
terms. It is not that it was the detriment.
No, true, my lord. But
Does not call for
My lord.
debarment.
in fact, the purchase order was for, say, XYZ.
You have put him to paralysis.
Hello.
Though he is alive, his movement is restricted.
restricted to applying for tenders floated within the next 1 year.
Yes.
Because
not-
but
and
that
it
is,
has
that
a-
is,
It has a ripple effect.
but that is a punishment. My lord. That is
It
a
has a ripple effect. And plus, apart from that, in the state government sector or public sector, in the private sector also, his reputation has been damaged. Just because he has done extra work to the extent of 3,23,000 at the instruction of the site engineer and engineer in charge. And that too after 3 years.
after 3 years and 3 months.
Something was moved. Something was recommended.
Oh.
Vigilance official recommended major penalty. And competent authority said recordable wording.
No,
And for them, recordable wording.
recordable
And for
warning-
him, it is civil death. This is
Lord,
not
I'll bow down to your lordships. Okay, my lord, there were errors on our part.
proportionate.
The errors on our part.
And 3 years. You refer to a subsequent guidelines. Do you think that it has statutory force which can be applied retrospectively?
There's the
No, it is simply guidelines.
these are guidelines. These are
By
guidelines.
no way it can be applied
In fact, the
retrospectively.
guidelines were, my lord, if I may
And public orders publicly made.
has to be construed in that manner.
Why cannot
Cannot circumvent and go and find a disseminate.
supplemented by an affidavit? You settle, there is a subtle change. No,
Mohinder Singh Gill is very clear on that matter.
no, that guideline. No, actually this guideline, that cannot be by the affidavit.
true, ma'am.
You have changed the stance.
Because that was a query which was.
I have definitely.
Yes, madam, and that is, we thought,
That came to my mind
Yes, ma'am.
directly.
and we wanted to address that also, my lord. so
Work
that-
was executed 2022.
22,
You refer to a guideline of 2023.
the warranty period was also.
Issued the show cause notice in 2025
Right.
and debarred him for 1 year for no reason at all.
No, I'll-
It is not a case of fraud. Okay, we'll conclude. We'll try, otherwise we'll reserve.
Much obliged.
Make it okay for my lord. The Khandelia, G. Khandelia. You were there? Huh? Roy, you want to say something?
He's a formal party, madam, my friend.
Khandelia for the petitioner. S. Bodhagur. Learned Counsel on behalf of Mr. S. S. Roy. Learned Central Government Counsel for the respondent number 1. And Mr. M. Sharma.
2, 3, 4, and 5, madam. 2, 3, 4, and.
Counsel. You're for IOC, right?
Yes, madam. 2, 3, 4, and 5.
Learned Counsel for the respondent number 2,
3, 4, and 5.
Legitimate. You want to add anything?
No, madam. No, madam. Your lordship has the extent of.
Okay. Really here, as all the respondents are represented, exchange of pleading is complete. An exchange of pleading is complete. The let notice be issued to stop as all the respondents are represented and the exchange of pleading is complete. And the learned counsel for the parties have submitted that the writ can be taken up for final consideration. The notice is made returnable forthwith. If I can dictate it today, I'll complete, otherwise I'll return
My lord,
CV.
I'm grateful.
Yes, any judgment?
Lordship, I rely upon that Blue Dreams advertisement.
Blue Dreams, okay, give it. I'll not refer to those, these are outside documents, Mrs. Sharma. You
My
can
lord, my
take
lord.
it back.
My lord. Please.
Much obliged.
Grateful.
Motion. Right, instructions. Instructions are there, my lords. Page 288, which undertaking he had given, he was found that revocation was done due to non-compliance of Rule 37. 37(3), which stipulates, my lord, payment of 25% of the total bid. Now, petitioner, my lord, he initially, which is admitted in page number 11 of the petition, admittedly, he paid only 10%, 15% remained. From 1903 till the date of flouting of this tender, my lords, we waited that he will come with that remaining 15%.
Okay, you produce the contemporaneous records,
My lords,
what transpired and what arrangement you have arrived,
yes, my lords.
because that is definitely submitted on instruction on 1/12/2025,
My lords,
right?
my lords. Our sole reason for this, because from that page 288, it transpires that he undertook to that he will pay. That 15% we waited till this year.
Show us contemporaneous records,
We'll bring it.
which are the verifiable records.
My lords. I'll bring the original record, madam. Because he quoted my lord 30 crores, something. Page 93, lordship will find his quoted price. Settled price, my lords, not quoted. Favorite cases.
37,
37.
sub rule 3,
Rule 3, my lord.
then at Roman 3,
Roman 3 and Roman 5.
before expiry of the period allowed.
Period allowed, my lord.
Right. What
Yes,
is
my
the
lord.
period allowed?
My lord, it's standard specific normally. And it's in these
There is
cases-
a discussion.
discussion. My lord. In his case, my lord, there was a discussion. It was given. He was to what page number is that? এই পিৰিয়ডটো ইমান দিন দিব লাগে বুলি 45 days, my lord. যিখন নহয় তাৰ এই 10% দিলে তাৰপিছত আৰু 15% দিব লাগে যে হোৱা নেকি দিয়ে এইটো পিছফালে আছে because my lord, there is another
You
rule.
produce the record
My lord, I'll produce the record.
from 2/1/2023 onwards.
2/1/23. Because otherwise also, my lord, the rule also mandates that commencement of the mining has to within 180 days. If it reaches that also, contract lapses. The bidding lapses, my lords. 250 days এটা আছিল নহয়
Heard Mr. B.D. Dekka, Learned Counsel for the People, and Mr. P. Gugoi, Learned Planning Counsel, Forest and Environment Department, for
respondent
for
of
the respond number. One, two, 3, 4, 5, 6,
my lords,
and 8.
yes, my lord, except 7.
Any government council?
Mines and minerals, my lord, they act on notice.
A competitive bidding process was initiated for under rules 32, 33, and 34 of the Assam Minor Mineral Concession Rules 2013. The rules 2013 and 32. For a mining concession area, mineral concession area as Tokta, Pandha, Hill, Stone, Quarry. Mining concession area for by an e-auction notice dated 11/11/2021. Stop, which were invited online from eligible bidders for settlement of the mining concession area for a stipulated quantity of 5 lakh cubic meter of stone for a contract stock permit period of 5 years at a reserve price of 10 crores. Full stop. In response to the e-auction notice, the petitioner and others submitted their bids. Full stop. The live action conducted for settlement was culminated on 23/12/2020, and the petitioner emerged as the highest bidder, which is offered bid amount of rupees 30 crore, 27 lakh, 77,719. Stop. And accordingly, full stop. Accordingly, a provisional letter of intent, LOI, was directed to be issued by the respondent number 5 on 9/3/2022. Full stop. Accordingly, full stop. Consequently, a provisional LOI was issued to the petition on 31/3/2022. With a direction, with a condition that the petitioner, with a condition that the petitioner had to prepare and submit all of one approved mining plan to clearance under the Forest Conservation Bracket of Act 1983, environment clearance as per EIA notification 2006 and 4, environment management plan within a period of 45 days from the date of issuance of the provisional LOI dated 31/3/2000. Full stop. There were communications were exchanged thereafter among the authorities in the subsequent period. Full stop. On 11/7/2020, the petitioner was asked to submit the requisite clearance of certificates, etc., within a period of 180 days. That is, before 39,022. Or else, comma, the mining concession. Or else the offer would be revoked. Full stop. On 13/7/2022, comma, the petitioner represented before the respondent number 78888 that was only in April 2022. Few formalities were completed. And remaining formalities were required to be completed by the statutory authorities. Full stop. On 14/7/2022, comma, the respondent number 7 granted approval to the mining plan full stop. What is 216 page?
Environmental clearance, Honor.
Ah.
Environmental clearance.
Environmental clearance was.
It was a recommendation to grant environmental clearance.
Okay. The respondent number 8
Yes, my lord, by the DFO.
wrote on 16/11/2022 to recommending grant of environmental clearance in respect of the in favor of the petitioner in respect of the minor or mineral concession area. Full stop. What is 217?
The terms of reference, no? Called the TOR. This is part of the environmental clearance.
So it was granted when?
My lord, this is terms of references will just lay down the condition.
Environmental clearance was granted.
The process is not complete.
Okay.
SIV8 certificate is due.
When the process for environmental clearance was under consideration, comma, the respondent number 8 on 21/1/2023. Sorry, respondent number 5 on 21/1/2023. Wrote to the respondent number 8 stating that he was directed to revoke the provisional LOI issued to the petitioner under Rule 37 within bracket 3 within bracket Roman 3 page 227 and Roman 5 and Rule 22 within bracket capital 1 and 2 of the 2013 rules, and to forfeit the initial bid security deposited by the petitioner and to initiate action for recovery of the unpaid balance of 15% of the bid security. Full stop. Para. It was para. Mr. Deka, learned counsel for the petitioner, has referred to a letter of a member of Legislative Assembly, letter dated 2/1/2020 of a member of Legislative Assembly, addressed to the Minister, Environment, Forest, Assam, whereby the Minister, Environment and Forest, Assam was requested to take necessary steps for revocation of the settlement process for a mineral concession area under reference on the ground of failure on the part of the petitioner to fulfill the terms and conditions of the LOI and to publish a fresh NIT for resale, as he had a supporter who can operate the minor concession area. To stop. It is Mr. Deka submitted that the process of revocation was perhaps triggered by the said letter of the MLA said letter dated 2/1/2023 of the MLA. And the same had resulted and the same and the letter dated 21/1/2023 was issued by the respondent of 5 post of. It was at this stage, the petitioner assailing Rule 37 of the 2013 rules and the decision to revoke the LOI preferred a writ petition, WBC number 686/2023. Post of. Para. On the writ petition, WBC number 686/2023 came up for consideration before a division bench on 13/2/2023. It was submitted on behalf of the state respondents that the respondent authorities would not proceed with retendering of the mineral concession area till 20/02/2023. Mr. Deka has submitted that Thereafter, a discussion was initiated between the petitioner and the respondent authorities. And it was represented the petitioner that if the petitioner withdrew the writ petition WPC number 686/2023, then the respondent authorities would review stroke reconsider a revocation order. Full stop. In fact, accordingly, petitioner submitted a representation undertaking dated 19/3/2025, indicating his intention to withdraw the writ petition, subject to review stroke reconsideration of the revocation order by the respondent authorities. Full stop. In fact, on 29/4/2023, the respondent number 8 wrote to the petitioner to submit details about the withdrawal of the writ petition. Full stop. When the writ petition came up for consideration again on 28/10/2025, it was submitted before the court by the learning counsel for the parties that there might be a possibility of reconciliation. Full stop. When the writ petition was listed again on 1/12/2025, it was submitted by the learned counsel for the parties, in unison, that the parties had arrived at an arrangement. Full stop. The petitioner, it was submitted on behalf of the petitioner that in view of such arrival of it was submitted on behalf of the petitioner that in view of the arrangement, the petitioner would not like to pursue the matter and sought leave to withdraw the writ petition with liberty to approach again in case of violation of any terms of the agreement. Full stop. But without proceedings any further with the conciliation process, the respondent authorities in the Environment and Forest Department have published a long auction notice, e-auction notice again on 12/2/2026 for settlement of the concerned mineral concession area again. So, Mr. Deka has submitted that the last date of submission of technical bid is fixed on 6/3/2026. And our bids would be opened on 7/3/2000, bids would be opened and evaluated on and from 7/3/2026 onwards. So, he has contended that by publishing the e-tender notice dated 12/2/2026, the respondent authorities have reneged on its representation that they would proceed further with the reconciliation process for settlement of the mineral concession area in terms of the provisional LOI issued to the petitioner on 31/3/2022. Full stop. Para, in response, Mr. Gogoi, Lawrence Standing Council, Environment and Forest Department has submitted that when the process of grant of environmental clearance was in progress, the period to submit the remaining 15% of the beach security had expired, and the same had necessitated for issuance of the revocation order. Full stop. Para. The matter would require a deeper examination, issue notice returnable on so and so, as Mr. Gogoi has appeared accepted 1, 2, 6, and 8. It's a formal note. Very copies by tomorrow. By tomorrow. The counsel for the petition shall furnish a copy of the petition along with annexure to the senior government Bogota Assam by tomorrow for service of notice upon the response number 7. Where the learning council for the parties are also heard on the indicator. From the facts narrated above, and more particularly, apart from the facts narrated above, it appears privacy from the order dated One 2025 that as regards settlement of the mineral concession area, the parties had arrived at an arrangement. Full stop. The parties appear to have arrived at a conciliation, and it was in view of such submission made in unison, a petitioner was granted leave to withdraw the petition with liberty to approach again in case of violation of any terms of the agreement. A petitioner has contended that the petitioner had submitted the undertaking to withdraw the writ petition as it was represented to him that the process of settlement of the mineral concession area would be taken to a logical conclusion and would be in his favor. Also. To appreciate such contention, examination of the contemptuous records would be necessary. Also. Privacy, also from the materials of record, it appears privacy that the conciliation stroke arrangement, stated to have been arrived at the parties as submitted on 1/12/2025, ought to have been brought to a logical conclusion. In the form of a regent decision. It is only after a regent decision, further steps in the form of a press auction notice to be called for. In the above way of the matter, it is ordered in the interim that the respondent authorities may proceed with the acceptance of the bids received in response to the press each under notice dated so and so. But the bids so received shall not be evaluated, opened and evaluated till the returnable. You accept, don't open. Otherwise, third party right again will be created.
My lord, can we seek liberty, my lord, indicated
Liberty
we can
the respondent authorities are what liberty?
we can pass orders, speaking orders, my lords.
It is up to you.
My lords, lordship will indicate that. That will create a bridge. That will.
No, I have said I'll examine the contemporaneous records.
My lords. Oh, then we cannot pass it.
So I am not granting that liberty now.
My lord is fixing a date, my lords.
One.
Obliged.
Yes. At what stage we were on the previous date? Mr. Goswami had made his submissions.
He has almost completed, Lordship.
Subject to reply.
Referred some judgment, Lordship.
Subject to reply.
Yes, Lord.
The only thing is that the impugn judgment was not read over. Impugn order was not read over. That
No,
was the.
Lordship,
He said perhaps that Deputy Labor Commissioner,
Deputy Chief Labor
Deputy Chief Labor Commissioner visited, if I remember correctly,
Yes.
visited the establishment of the Oil India Limited,
Yes, Lord.
Oil India Limited, and met 8 contract laborers With about 8 contract laborers, with about same number of permanent employee and recorded their statement or something like that and came to an opinion that the permanent employee, whatever the emoluments or pay or remuneration they are getting, the contract labor should also get the same.
No, not also should the game.
Minimum.
Some parity should be made.
Parity.
Hmm.
Parity. And
Actually,
then accordingly recorded the same in the opinion. And some increase in the
Five,
at the minimum of the pay scale or whatever. And according to his submissions, that is not the manner in which a pay parity can be done. As per the established laws, many parameters are to be examined for pay parity and thereafter only can decide. So this is one. And secondly, perhaps, I am just from my memory, not from the record, right? And some settlement. Settlement is binding. So as per section 17 or something.
Section 18.
Section
18. 18. So the whatever subsequent employees or say union, they would also be bound by
the conciliatory settlement.
Right. Something like that. This is what.
And another one submission is the contractor not made as a party response, contractor. Because they are the contract laborers, they are under the contract labor.
Actually, this
contractors are not
petition, this point was urged in the writ petition, but it was not placed before your lordship.
He will,
That is not argued.
he will argue.
He will argue that.
So
Though
you
this-
just give me the points in a bullet point wise in a 1 page or 2 page.
Yes.
Right.
So if he argued, then I have to answer. One thing that he has stated that so far the equal pay for equal wage is concerned, some other factors are to be considered. Only one of such factors is the mode of recruitment, mode of responsibility. So only on this only on consideration of those things, the equal pay for equal wage can be conferred. According to him,
so far as
the
service jurisprudence is concerned, I don't know the principle of law regarding pay parity in labor law, but other government sector, say civil secretariat or anything, pay parity, there are many factors.
Yes,
which cannot be decided by the court also. It is a
Executive
domain
action.
of experts.
Executive
And there are
action.
many heads which are to be
considered.
So I know about that. I don't know about the labor law, but he said and he submitted also few cases that same matrix is applicable.
Constitution to mention.
Okay, just a minute for my understanding. 2086.
No, Lordship is 0/17.
I for it's 8150. Here the somebody submitted. This is Oil India Thika Shramik Sangha. Respondent, private respondent. And Mr. Dasgupta, you represent. And in the other one also, there is another labor union. You represent. Okay. Submission should be same or different?
More or less same it would be.
Law is same, Lordship, law is same. Only in respect of that case, they have also approached the labor court, Lordship, by filing a reference case. Reference case was initiated and accordingly for regulation, Lordship. That case was dismissed. Only that facts we have to face. In addition to what has been already placed before in this case.
Let me try to understand. Yes. You are in 8150. 8150?
Yes.
81.
Is the name Oil India and the manner and referring to Contract Labor Act, he made some submissions.
Oh, yes. Especially Rule 25. Rule 25 of Contract Labor Regulation and Evolution Rules 1971. According to him, there are different aspects to which the wage can be fixed. One of such aspect is settlement, and here there is a settlement, so there is nothing more to be done. That is his case. And third one is, so for the equal pay for equal wages, we are not of the same footing, so pay parity cannot be conferred.
Rule 25.
Your Lordship, that is Rule 25, 5A of the Contract Labor Regulation Evolution Rules.
25, subsection 2, Roman 5.
Roman 5A.
A, right?
And some bearing you have section 7. Section 7 and section 12. Uh, 25, Lordship, got it, no?
Yes. 12.
Section 12, should I read 25? Or
25. 25.
Rule 25. And he also made submission on section 12.
Section 12 of?
Of the Contract Labor Regulation and Evolution Act and section 7.
I don't remember 12 and 7. I don't remember 12 and 7. 7? Oh,
Seven,
I'm sorry. I'm
probably
sorry.
7 he has not argued. Probably,
I'm sorry. I'm sorry.
probably argued 7.
I'm sorry.
12. I don't know whether he argued 7 or not.
Okay. Okay.
These are the parameters of his argument. Now let us go through the provisions first before starting our case. Provisions of the Act. Then our burden will be lessened. Now, Lordship, Contract Labor Regulation and Evolution Act was enacted in the year 1970. Basic object of this act is to abolish the contract labor system of contract labor. If it is not possible to abolish the system of contract labor, engagement of contract labor, then it should be regulated. The condition of service of the workmen should be regulated. That is a beneficial legislation. It should be regulated. 3 modes have been prescribed for the basic 3 modes, 3 or 4 modes have been prescribed for its regulation. One is section 7. By the dint of section 7, every employer who wants to engage contract labor, they should be registered under this act. And this registration shall be done by a number of registered within a certain locality, and these registers are generally gazetted officers. First thing is that in order to engage any contract labor, you have to get yourself registered under this act. That is the mandate of Section 7. Another thing is that the contractor who will supply the contract labor, he must obtain a license. That is very much important. Rule 25 deals with this license. He must obtain a license from a register. And this license shall contain the particulars of number of workers he would apply, he would engage. All these things, particulars will be there. I will later on I shall elaborate. Sure. And one of such condition is that in the license itself, the condition of service of the contract labor should be indicated. What will be their wage? What is the other conditions? That should be prescribed. And rules in this regard made under Section 35 of the Contract Labor Regulation and Evolution Act, a rules in this regard has been made. And in these rules, Rule 25 is essential. Is stated what is the conditions of this.
Okay, oh, that is Rule 25.
That is Rule 25.
I thought that's Section 25.
Rule 25. This rule is framed under Section 35 of the Contract Labor Regulation and Evolution Act. And Rule 25 deals with the license. And this license shall contain the terms and conditions of the, just briefly I am stating it, thereafter I will refer the in detail below. Before the last session, 10 minutes time is there. This rule stated that what will be the wage of a contract labor. Look, the contract labor is under two employers. One is principal employer and other is contractor. Principal employer will definitely, he will want to have his profit by engaging contract labor, and the contractor who will engage the contract labor, he must have some intention to have his profit. And ultimate payment will be paid by the principal employer. So there is a chance of exploitation to the maximum extent. And if we go to the defined judgment, this is indicated. There is a chance of exploitation, and for this purpose only, the Contract Labor Regulation and Evolution Act was enacted. If we go through the preamble of this act, it will be evident from this preamble that the contract system of engaging the contract labor should be abolished, and if it is not preamble, statement and object of the act, the statement of the in practice of engaging contract labor should be abolished, and if it is not possible, then it should be regulated. Now, let us come again. Now, let us come to the provisions of Section 12. Section 12 laid down that if a contractor wants to supply some contract labor in an establishment, he must get himself registered under this act, and this provision has been made under Section 12. Now, what are those conditions to be incorporated in the license? That has been spelled out under Rule 25. 25, 5A and 5B. I will come later on. Basically, here what they want to say, the contract labor should not be, they must get minimum wage at least. Appropriate government fixed minimum rate of wages, at least by any stage of imagination, by any case, the contract labor should not get wages which is less than minimum. That should be kept in mind. However, they may get more than the minimum wages, no problem. For that purpose, some agreement or settlement, what is their case, I am coming, or settlement can be made. By making certain settlement, you can fix their wages, but while fixing their wages, the wages should not be less than the minimum rate of wages. It may be above minimum rate as possible. These two conditions are to be kept in the mind. Third condition is that if it is found that work performed by the contract laborer and that of the employees of the principal employer are of similar, same or similar nature, not equal. It must be bear into mind. It is not equal as contained in the directive principles of the Constitution. Article 39 probably, 39D probably. I will come to later on, below. Same and similar, if they perform same and similar wages, then their wages shall be not equal, same or similar. Now, if there is any dispute, whether they are performing same or similar nature of job or not, that dispute can be resolved by an official. Initially, when this act was enacted, this official was Chief Labour Commissioner. Subsequently, this official is Deputy Labour Commissioner. Now, no? Deputy Chief Labour Commissioners. I'm sorry. Deputy Lord Labour, Deputy Chief Labour Commissioner. He is the person who can make such an inquiry. Now, here what had happened, the employees were paid with their wages in terms of the settlement. What is their case? In terms of the settlement. Now, union raised a demand. See, we are performing same and similar nature of job. So we should be paid with the same and similar wages as being paid to the permanent employee. Here the problem is there. They want to say, you see, your settlement is a conciliatory settlement. Industrial dispute comes there. Your case is a conciliatory settlement. It is binding on you. You cannot get rid of this settlement. It is binding on you. So you cannot claim this same or similar nature of job as contained in Rule 5A. Now, for that purpose, I will bring one provision. Basically, this is a beneficial legislation. And the benefit conferred under this act should be restored or should be kept preserved. For that purpose, a section, I will later on I will give you details, just give you the picture. A section called as Section 30. Section 30 of the Act has been enacted. And this section states that whatever benefit is available under this Act, that should be preserved, notwithstanding anything contained in any other agreement or any other law being enforced. So naturally, my mode of argument will be that yes, conciliatory settlement is there. I am getting my salary under the conciliatory settlement, but my case is that I am performing equal work. So my case should be determined by this. And there is no bar on the rule itself, because this rule itself stated under what circumstances the wage may be fixed. Now it is one.
Okay, I'll resume.
I will just refer those sections so that it will be easy to your lordship to understand this rapidly.
You said section 30.
Section 30. For the time being, the provisions of this Act shall have effect notwithstanding, she got it?
Yes.
Notwithstanding anything inconsistent therewith, contained in any other law, or in terms of any agreement, or contract of service, or any standing orders applicable to the establishment, whether made before or after commencement of this act. The proviso is very much important, proviso and subclause 2. Provided that where there is any such agreement, yes, any agreement will be applicable. But if this agreement is favorable, then it will be applicable. If it is not favorable, then it will not be applicable. It will be applicable to other things. Provided that where any such agreement, contract of service, or standing orders, the contract labor employed in the establishment are entitled to benefits. We are getting benefits under the settlement. Benefits in respect of any matter which are more favorable to them. That is very much important. We are getting our wages in terms of the settlement, and if we get more favorable thing in terms of clause 25, rule 25(5)(a), then this rule 25(5)(a) will be applicable. More favorable to them than those to which they would be entitled to under this act. The contract labor shall continue to be entitled to more favorable benefits. That is very much important. More favorable benefits in respect of that matter, notwithstanding that they receive benefits in respect to other matters under this act. Now, clause 2, nothing contained in this act shall be construed as precluding any such contract labor from entering into agreement. Despite this, entering into agreement with the principal employer, with the contract or the contractor, as the case may be, for granting them rights or privilege in respect of any matter which are more favorable to them than those to which they would be entitled to under this act. Now say, I am entitled to have equal wages as being paid to the principal employer. Even then, I can enter into a contract with the principal employer to have the more wages. So let us have a cup of tea and then let us come. So basically my argument will be in that line. And only another thing is that so far the equal pay for equal wage is concerned, and so far this is concerned, there is a distinguishable features. Because so far the equal pay for equal wage is concerned, that is derived from the directive principles. Directive principle is not enforceable. However, while taking executive action, the principles enumerated in the directive principles shall be looked into. So there is no such legal provision to the effect that merely because I am performing the same job, I am entitled to have. Unless there is no such issue, then these directive principles were brought within the domain of Article 14. Initially, the court granted relief in the year 1982 onwards. Then thereafter, they have departed. A series of cases, only because you are working the directive principle, only you are performing equal job, you are not entitled to have the equal wages or equal salary. But in our case, this principle will not be applicable. Supreme Court also indicated, because there is a specific legal provision as contained in Rule 25(a). But so far those cases are concerned, there is no such legal principle. And I have gone through a case, Airport Authority, Madras High Court case. But this aspect of this case was specifically dealt with, nicely dealt with. I will refer to judgment. All the judgment which they have placed before your lordship have been referred in.
Item number 4, I am appearing for the respondent. The case has not begun as yet. So as soon as it is begun, my lord, I have already prepared my written submissions. For the timing, let me ask Gupta do it.
Okay.
We have attended a sufficient. Okay.
Now, I will refer the relevant provision, some relevant provision. Statement and objects, my lord. Probably illustrated in this book, no? Page 1. Clause 2, paragraph 2. Relevant portion I will refer to. The proposed bill aims at the abolition of contract labor in respect of such categories as may be notified by the appropriate government in the light of certain criteria that have been laid down and regulating the service conditions of the contract labor where abolition is not possible. This much I would like to refer. Now, for the purpose of regulation, the lordship straightway for the time being, Lord, I may like to refer section 2C. Who is a contractor? Page 3.
To see, yes.
Contractor in relation to an establishment means a person who undertakes to produce given result of the establishment other than mere supply of goods or articles or manufacture to such establishment through contract labor or who supplies contract labor for any work of the establishment and includes subcontractor. So if any person who undertakes to go do something on behalf of the principal employer, he will be a contractor, or he may be may be called as a contractor if he supplies the contract labor for the purpose of the principal employer. But the person concerned who supplies the materials, etc., they shall not be considered as the contractor. Now, straightway, let us come to, let us skip 3, 4. This is not relevant for our case. Section 6. Page 6.
Yes.
Appointment of registering officer. The appropriate government may by order notified in the official gazette. The appropriate government may be the state government or the central government. So for our case is concerned, it is central government. The appropriate government may by an order notified in the official gazette appoint such person being gazetted officer of government as it thinks fit to be registering officer for the purpose of this chapter and define limits within which registering officer shall exercise such power conferred on him by an order in this act. So some gazetted officer will be appointed for certain zones for the purpose of serving as a registrar. Now, section 7. Registration of certain establishments.
Yes.
Every principal employer of an establishment to which this act applies shall within such period as the appropriate government may by notification in the official gazette fix this behalf with respect to establishment generally or with respect to class of them may make an application for registering the officers in the prescribed manner for registering of the establishment. This much is sufficient. There is a proviso that deals with the limitation period. Now, subclause 2, if the application for registration is complete, in all respect, the registering officer shall register the establishment and issue to the principal employer of the establishment a certificate of registration containing such particulars as may be prescribed. So far the principal employer is concerned, if he wants to engage some contract labor, he must get himself registered under section 7. Now also come to let us keep 8, 9, 10, 11. Now chapter 4, page 9.
Yes.
Appointment of licensing officer. Same, the appropriate government may by an order notified in the official gazette appoint such person being gazetted officer of government as it thinks fit to be a licensing officer for the purpose of this chapter and define limits within which a licensing officer shall exercise the power conferred on the licensing officer under this act. More or less same like registration officer. Now, so far our case is concerned, section 12 is pertinent. Licensing of contractors.
Yes.
With effect from such date as the appropriate government may by notification in the official gazette appoint no contractor to whom this act applies shall undertake or execute any work through a contract labor except under and in accordance with the license issued in that behalf by the licensing officer. Now, subclause 2, how the license will govern. Subject to the provisions of this act, license under subsection 1, here it is important, may contain certain conditions, such conditions, including, in particular, condition of hours of work, fixation of wage. That is very much important. So far our case is concerned. Fixation of wages and other essential amenities in respect of the contract labor as the appropriate government may deem fit to impose in accordance with the rules, if any, under section 35, rules if any made under section 35 and shall be issued payment such fees and deposit of such sum, if any, as security for the performance of the conditions that as may be prescribed. So the license itself contains those conditions. What would be the condition of service of the workers? Now, it contains that is subject to the provisions of this act. Now, Your Lordship, come to Rule 25 of the Contract Labor Regulation and Abolition Central Rules.
Yes.
Page 25. 25, man? Page 24 it starts. Forms and terms and conditions of license. Every license granted under subsection 1 of section 12, just now you have read it, shall be in the form 6. Clause 2. Every license granted under sub-rule 1 or renewed under Rule 29 shall be subject to the following conditions. Namely, the license shall be non-transferable. The number of workmen employed as a contract labor in the establishment shall not be on any day exceed the maximum numbers specified in the license. Save as provided in the rules, fees paid for the grant as the case may be for renewal of the license shall be non-refundable. Clause 4. The rates of wages, that is important. The rates and wages, the rates of wages payable to the workmen by the contractor shall be not less than the rate prescribed under the Minimum Wages Act. This is one of the area where the condition of service of the workers are regulated. By any means, you should not pay any wages which is less than Minimum Wages Act. For such employment, where applicable and where the rates have been fixed by agreement, that is important, right? Where the rate has been fixed by a agreement, settlement or where award not less than the rate so fixed. So any agreement or settlement, whatever may be, through which the wages are fixed, it should not be less than the minimum wages. Now 5A and 5B will cover our case. So what we found that one thing is that the wages shall not be less than the minimum wages. Wages may be fixed by an agreement or settlement, but such wages which is fixed by the agreement or settlement shall not be less than the minimum wages. That is the indication that has been given by clause 4. Now 5A. Where 5A, in case where the workmen employed by the contractor perform, that is important, perform the same or similar kind of work as the workmen directly employed by the principal employer of the establishment, the wage rates, holidays, hours of work, and the other condition of service of the workmen of the contractor shall be the same as applicable to the workmen directly employed by the principal employer of the establishment or the same or similar kind of work, provided that in case of any disagreement with regard to the type of work, the same shall be decided by the Deputy Chief Labour Commissioner Central. So from the contents of clause 5A and 5B, what we get, that a contract labor should not get the less than the minimum wages. His wages may be fixed by an agreement or settlement, but this agreement and settlement shall not prescribe any wages which is less than the minimum wages. That apart, if the contract worker performs same or similar nature as being performed by the principal employer, then he shall be paid with the equal wages as being same or not very much equal, same or similar wages as being paid to the principal employer. And if there is any dispute whether they are performing same or similar nature of dispute work or not, that dispute shall be resolved by the Deputy Chief Labour Commissioner. Now their case is that we are paying more than minimum wages. For that purpose, on that day, they have referred several notifications issued by the central government and the state government. Further case is that in our establishment, wage payable to the contract laborer have been fixed by settlement. Third point is that it is not only a settlement, but it is a conciliatory settlement. Industrialist
Yes.
And when there is a conciliatory settlement, that settlement is binding to all persons, whether you are a party to the settlement or not. That is their case. For that purpose, they have drawn your lordship's attention to the provisions of section 18 of the Industrial Dispute Act.
Section 18.
Section 18 of the Industrial Dispute Act. So could I read it again?
18, okay. Let me have a look. Yes.
Then let us read slowly. Person on whom settlement and awards are binding. Number one, A. If settlement arrived by agreement between the employer and workman, otherwise than in course of a conciliation proceeding, shall be binding to the parties to the agreement. So settlement may be of two kinds, Lord. If there is an agreement between the direct agreement between the employer and employee, that will be also a settlement. And if the settlement is arrived in with the intervention of the conciliation officer, then that will be called as a conciliatory settlement. So for this purpose, your lordship may or may not go to the provision of section 2P of the Industrial Dispute Act.
2D.
2P.
P. What is 2P?
मूड की तरफ जाए मूड टू जाए
Okay, 2P.
अपना to answer you. That will find the lordship as a page 17.
Yes.
I don't know whether that is. Settlement means a settlement arrived in course of conciliation proceeding and includes a written agreement between the employer and the workman and arrived at otherwise than in course of conciliation proceeding where such agreement has been signed by the parties thereto in such manner as may be prescribed, and a copy thereof shall be sent to the officer, to an officer authorized in this behalf by the appropriate government. So settlement may be of two kinds, direct settlement or settlement at the instance of the conciliation officer. So what will be the effect if the settlement is arrived at the instance of the conciliation officer, which is called as conciliation officer, conciliatory settlement? And the purport of section 18 is that if there is a conciliatory settlement, it will not bind to the parties to the agreement, but it will bind to all. Your lordship will find probably it is subclause 5 or something. Section 8, your lordship come.
Section
18, sorry.
18.3.
18.3. A settlement arrived in course of a conciliation proceeding under this act or an arbitration award in case where the notification has been issued under subsection 3A of section 10A, an award of the Labour Court Tribunal National Demand which has become enforceable shall be binding on all parties to the industrial dispute. All other parties summoned to appear in the proceeding as parties to the dispute unless the board, arbitrator, Labour Court Tribunal or National Tribunal, as the case may be, record the opinion that they were summoned without proper cause. C. Where a party referred in clause A or clause B is an employer, his heirs, successor, assigns in respect of the establishment to which dispute relates. Where the party referred to a clause A or clause B is composed of the workmen, then all persons who are employed in the establishment or a part of the establishment, as the case may be, to which the dispute relates to the date of the dispute, and all persons who subsequently become employed in that establishment or part. So if there is a conciliatory settlement, it is binding to all. The employer and subsequent employer, workman and the subsequent workman. So by referring this clause, what they want to say that you see we are having 2 or 3 conciliatory settlement, and you are binding by the you are bound by those settlement as it is a conciliatory settlement. So you cannot, when you are regulated by this settlement, you cannot claim for equal pay for equal wages as contained in clause 5A. That is their case. Clause 25 5A. Sorry, Rule 25 5A. Now, Rule 25 states define modes of fixation of wages. One is minimum wages, other is settlement, and third one is that if you perform equal nature of job, then so there is no bar that despite having a settlement, you cannot claim under section 5A. From the contents of Rule 5A itself clear. 25, sorry. 25 5A itself clear.
So you want to say that despite a conciliatory settlement, the workman can still
pursue
for
because of
better,
Rule 20
for better wages.
for better wages, because there is a specific period.
If they perform same or similar.
That is the
similar
purport of the
and it is the deputy chief
labor commissioner
who can decide the issue.
If there is a dispute. Now, their contention is that no, you cannot. So it's up to your lordship to decide.
There is one.
Mm.
Second, going further, he said that the manner in which he has decided the issue of equal pay for equal work.
That is not proper manner.
Not the proper one.
I will come to
The
that.
kind of inquiry he initiated.
Yes.
Or exercise he had undertaken was not the one which can be taken for the purpose of
Fixing a salary, fixing of wages. Not proper way.
not the proper way. The manner in which.
And their main contention was that, all right, you have considered one factor, that is the wages payable to the grade 1 employees. And we have also given it to them. It is not that we have not given it to them. But you have added certain other amount. That is their sole anxiety. Why this amount was added? And what is the basis? Why you have added this thing? You have not assigned any reason. You have not stated the basis. That is their contention. Now I will come to this point later on, Milord. Just a minute. Now we are on conciliatory settlement. Now, in order to fortify my case further, I would like to refer section 30. Oh, I should move to the adjustment. That is, if you are having the Universal Care Act, it is at page 15. Now the order was passed by the Deputy Chief Labor Commissioner in exercise of his power conferred under Rule 25 5A. Effect of laws and agreement inconsistent with this act. So what is their contention? That the order which was passed by the Deputy Labour Commissioner Central Labour is inconsistent with the settlement which we are having. This settlement is not only a settlement, but it is a conciliatory settlement. It is inconsistent with this order. That is what they have said, as I have understood from the argument. In order to fortify their contention, they have referred section 18 of the Industrial Dispute Act. Now, effect of laws and agreement.
Yes.
The provisions of this act shall have effect, notwithstanding anything inconsistent therewith contained in any other law or the term of any agreement or contract of service or any standing orders applicable to the establishment, whether made before or after the commencement of this act, provided that where under any such agreement, a contract service or standing orders, the contract laborers employed in the establishment are entitled to benefits in respect of any manner which are more favorable to them than those to which they would entitled under this act. The contract laborer shall continue to be entitled to the more favorable benefits in respect of other measures, notwithstanding that they receive benefits in respect of the other matters under this act. So two things is there. If I am getting something under this act, but if I am getting something under any settlement or agreement, it is to be seen which one is favorable to me. If it is favorable, if agreement is favorable to me, I shall get the wages in terms of this agreement. If it is not favorable to me, then I shall get the wages in terms of this act. Proviso and clause 1. May I read it again? Let us read it again. Two things are stated. The provisions of this act shall have effect, notwithstanding anything inconsistent therewith contained any other law. If there is law, any other law which is inconsistent, then it will, this provision will be.
If this part is read, then 25 to 5A would prevail. Okay.
Otherwise, because I need not take the recourse of this section, because 25 to 5A itself is very much clear that fixation may be done in this way.
It will have effect.
Yeah. So in order to keep me in a safer side, I am referring this.
Then or.
Or.
Yes. Or. In the terms of any agreement.
Your Lordship is reading section 30.
30 I am reading.
The provisions of this act shall have effect notwithstanding anything inconsistent there contained in any other law of.
It is a provision which will have effect. May not be the decision.
Yes.
Provision will have effect.
So decision made under that provision.
Whether that will have effect.
Will have effect. So our case,
the decision is erroneous.
If the decision is erroneous, then it will not be
That will not have effect.
Yes, that I have to clarify, Your Lordship.
Yes.
I have to clarify.
Provision, the 25 to 5A, that will have effect, notwithstanding anything. He can go for, suppose your submission is accepted, he can go for, if in case of disagreement, he can go and decide. Right?
Whether the
Their
decision
second-
making, if the decision making process is defective,
Yes.
what your lordship's anxiety is that if the decision making process is, then this will not apply.
Huh.
That is
First
what-
part of it.
First part will not apply because you have not followed the decision. You have not followed the procedure as established by the law.
That
So-
may be one. Because-
That is one.
We are in a exercise of power of judicial review, right? Only that much.
That much.
We are not into the facts and all.
No, I am also not referring the facts. Whether we are within the bound of the jurisdiction.
Oh, yes. And second part of subsection 1. Or there is
Or.
in the terms of any agreement.
Hmm.
Now, agreement does not include conciliation
Agreement is concession settlement.
because you have made submission that
They have referred some conciliatory settlement.
subsection 1 of section 18
Hmm.
a settlement arrived at by agreement.
Hmm.
So that is agreement.
Agreement.
Subsection 1.
Yes.
And both of you are referring to conciliatory
Settlement.
settlement.
Yes.
So in terms of any agreement,
Conciliatory
so there
settlement.
it include conciliatory settlement.
Every conciliatory settlement is an agreement. But every agreement is not a conciliatory settlement.
Yes.
Reverse is not correct.
Reverse is not correct.
Not correct. But
Agreement is the base.
base.
And it can go further.
Further, if it is made at the instance of the conciliatory
So
officer.
agreement is at subsection 1 of section 18.
18.
Conciliatory settlement is at subsection 3,
3.
going further.
Further.
Right?
So every conciliatory
So now,
settlement.
in terms of any agreement, whether that includes conciliatory settlement.
Yes. Because every conciliatory settlement is an agreement.
But that is why that
Ah.
a conciliatory settlement includes an agreement.
Yes.
But every agreement is not conciliatory
Yes.
settlement.
Yes. That is correct.
Right. Here the mention is made any agreement,
Any agreement.
whether that includes conciliatory settlement.
Yes, definitely it will include.
No, that if we go by that, then it may not.
If your lordship come to section 2P.
We'll go to that 2P.
2P.
2P of
Industrial Dispute Act.
I have seen agreement is not defined. Already I have seen. Agreement is not defined. Settlement is defined.
Settlement. Settlement is an agreement.
Settlement includes agreement.
Yes.
But agreement may not include settlement.
Yes. No. Agreement, every agreement shall be a settlement. Every agreement will be a settlement. Whether it is in the law of contract also, every contract is a settlement between the parties. But so far the industrial dispute is concerned, settlement at the instance of the conciliation officer. Good answer. 2P2, huh? Page 17, huh? May I read it? Settlement? Settlement means a settlement arrived at in course of conciliation proceedings. All right. And includes.
Right.
And includes a written agreement.
Settlement is broader.
Agreement
is lesser.
But it includes a settlement.
Means and includes is an
Yes,
inclusive.
that means every settlement is an agreement. Whether very much clear. Settlement means a settlement arrived in the course of a conciliation proceeding. All right. So if it is not in the course of a conciliation proceeding, then also it will be a settlement and includes a written agreement.
So it is like
So
settlement is a genus.
yes, yes,
Agreement is a species.
yes. No, agreement is genus. Agreement is genus, ulta, reverses. Agreement is genus and settlement is a species. Any contract between two persons is an agreement if it is in terms of a law, not but settlement means a settlement arrived in course of a conciliation proceeding. Two things, Lord. Straightway, one person may entered with the agreement with the other. Then it will be an agreement. But if such agreement was made at the instance of the conciliatory officer, I will refer section 12 if so required, then it will be a conciliatory settlement. A settlement means a settlement arrived in course of a proceeding includes. So every agreement, if for the timing, if we skip up this phrase, arrived in course of a proceeding, then settlement includes a written agreement. For the timing, let us keep up this phrase. Settlement means arrived in course of a conciliation proceeding. Let us keep up this phrase. Settlement means and includes a written agreement. Written agreement between the employer and workman arrived otherwise than in course of a conciliation proceeding. That will be very much clear. One is in course of a conciliation proceedings and includes a written agreement between the employer and the workman arrived at otherwise than in conciliation proceeding. So a settlement may be arrived in course of a conciliation proceeding, or it may be arrived through an agreement other than the in course of a.
So settlement word is conspicuously missing in section 30. Word settlement is conspicuously missing in section 30.
Yes. Conspicuously missing in section 31. Yes. I have to clarify this thing.
Yes, because agreement is one without intervention of any third party.
Yes.
It is the employer and the management. But conciliatory settlement is in the presence or maybe with the intervention of a third party, that is conciliation officer or deputy chief labor commission.
Yes,
right?
yes.
Then suppose those settlements were made in presence of whom?
Conciliation officer.
Conciliation officer. And
that is a conciliatory settlement.
Conciliatory settlement. That is section 18.
No. What is conciliatory?
2020?
No.
18, section 18 or 25?
No. Before going
18,
to 18. Before going to 18, your lordship may please come. Oh, yes, before. All right, let us come to the 18.
18.
You see, yes, that will be very much clear. Your lordship anxiety will be clarified here from the contents of section 18. A settlement arrived. Agreement is a settlement. A settlement arrived at by what I told you, that is fortified by content of subsection 1. A settlement arrived at by agreement between the employer and the workman, otherwise than the in course of conciliation shall be binding on the petition. So, if it is not in course of a settlement, conciliatory proceeding, then also it will be a settlement. Am I wrong? A settlement arrived at by agreement between the employer and the workman, otherwise than in course of a conciliation proceeding.
My slight dilemma is that
Hmm?
the just my query will be this: a settlement by way of conciliation
That is conciliatory settlement.
has been arrived at
Hmm.
between the parties
Hmm.
in presence of, plus maybe at the intervention of the conciliation officer.
Yes, conciliation officer.
And that conciliation officer is a specified one, or he is the same person, deputy chief labor?
No. Define. I will place a define.
Right.
That
So,
conciliation officer
if
will
something is arrived at the intervention of
any conciliation officer.
conciliation officer, then whether going because of the word, the agreement appearing section 30, whether going beyond that,
Yes.
right, under section 25(2)(5)(a).
No, your lordship anxiety is that whether it is a settle, whether any agreement will be a settlement or not.
No, conciliatory.
Hmm.
Conciliatory settlement or not.
Whether, no, definitely not. If it is at the instance of a conciliation officer, then it will be conciliatory settlement.
Because at places different, because section 30 says any agreement, right? Then section 18,
Miller,
any settlement arrived at by agreement is also settlement.
Miller, one thing that has to be bear in the mind, any agreement. So agreement may be arrived between the two parties.
Right.
Without intervention.
Right.
And any, second, just a bit. And any agreement at the instance of the conciliation officer. That will be also an agreement, but this agreement will be called as a conciliatory settlement. That is fortified by contents of section 18. No, because purport of the section 18, section 30 is that whichever is beneficial to the workman, contract labor, that should be applicable.
So, settlement includes an agreement.
Yes. So
not
any,
the vice versa. Not the vice versa.
Not vice versa. Any agreement includes a conciliatory settlement. Settlement includes.
That is not fitting in. That is why I am asking you. That is not fitting in my mind because settlement includes both.
Agreement as conciliatory settlement.
Right. Right.
Now, conciliatory settlement
includes agreement, but not vice versa.
Yes.
If you go by this,
yes,
the definition of settlement.
I think Lordship may read it section 2P.
I am reading it
with 12 free. 12 free.
I will refer to 12 free.
No, I have been reading it together. 2P, 2P, section 30, subsection 1, section 18, 3. I have been reading it.
No, Lordship, with 12 free.
I will refer it. Don't worry.
12 free of which act?
ID Act. 2P read with section 12 free.
No,
I am candid that it is not fitting in.
Yes.
In my mind. So that is why I've been asking you queries.
No, for the time being, let us keep it up. Let us come to the rule 25. Or if your lordship go to section 12.
Let us see, he is referring to something.
All right, definitely. Prior to section 12, let us come section 4. Conciliation officer defined.
You want to say section 4.
12(3).
12(3), I have
Yes.
read.
Because
No, let
that's-
us read the entire phrase.
Just
What
to-
we want to go to.
because 2P, it says that settlement means a settlement arrive at in the course
Let
of
him argue.
consultation.
No.
I'm only pointing out.
No, that's all
No,
right.
I'm
No,
only
because
because
point.
on deliberation.
No, it is not regarding merit.
I'm
Yes,
not
I am
having-
trying to state, this is statutory
No,
provision.
hold on,
here.
hold on. I will refer just, let him, he may have some idea, better idea. Let him.
Okay, it's okay, 2P. 2P I have read.
Yes.
Yes, Mr. Das, please continue. 2P.
So 2P got it. The purport of the 2P is that there is an agreement. There may be an agreement between the employer and employee. If this agreement is made at the instance of the conciliation officer, then it will be called as a conciliatory settlement. Am I wrong? I think so.
Okay, let us proceed.
Now, my lord, come to section 4. Who is a conciliation officer? The appropriate government may by notification in the official gazette appoint such number of persons as he thinks fit to be conciliation officer charged with the duty of mediating and promoting the settlement of an industrial dispute. So he has some duty to make mediation. The conciliation officer may be appointed for a specified area, that is not very important, specified area for a specified industries or specified area for one or more specified industries and either permanently or for a limited period. So that is the duty conciliation officer. Now, duties of the conciliation officer. That is section 12. Where any industrial dispute exists or is apprehended, the conciliation officer may, where the dispute relates to a public utility service and a notice under section 22 has been given, shall hold conciliation proceeding in a prescribed manner. That is not very pertinent so far our case is concerned. In a public, when there is an industrial dispute in a public utility service like refinery, etc., then the conciliation proceeding must be held. The conciliation officer shall, for the purpose of bringing about a settlement of dispute without delay, investigate the dispute and all matters affecting the merits and the rights settlement before, and may do all such things as he thinks fit for the purpose of inducing the parties to come to a fair and amicable settlement. It is the duty of the conciliation officer, not very important. If a settlement, that is my learned friend referred, subsection 3, if a settlement of dispute or any matter in a dispute arrived at in the course of a conciliation proceeding, the conciliation officer shall send a report to the appropriate government or an officer authorized in this behalf, the appropriate government, together with the memorandum of settlement signed by the parties. He owes an obligation to send the matter to the appropriate government, a copy of this matter. This is, and so far 4 and 5 is concerned, it is not relevant so far our case is concerned. 4 is that if there is no settlement arrived at, then the conciliation officer shall find submit a failure report, and 5 is something defined. It is not very pertinent for our case. So my case before your lordship is that Rule 25 specifically states 3 ways of fixing salary, wages. One is automatic by
Minimum wage.
minimum wage. Second is by agreement.
It could be above minimum wage.
It could be above minimum wages. Second is by agreement. And now again, agreement include page number, Here you see. Here, the rates of wages payable to the workman by the contractor shall not be less than the rates prescribed under Minimum Wages Act, 1948, or for such employment where applicable, where the rates have been fixed by agreement, comma, settlement, or award. Award means it is an adjudication by a labor court or the industrial tribunal.
Which section you are reading? Section?
Section not Rule 25 of the
Rule
Contract
20.
Labor Regulation and Evaluation
Rule
Central Rules.
Rule 25.
That is for the implementation of Section 12. Subsection, subclause 2.
So how to read it together?
Yes.
Question is how to read it together.
Together.
Because 18 says, subsection 3 says it is binding.
Subsection 3 says.
Subsection 3.
Yes, that
18.
is.
And
yes.
section 30, it is conspicuously that settlement is not there. It is agreement is there. Right? Though word settlement includes agreement, then it should have been settlement.
Yes.
In section 30. That is not there.
All right.
So settlement includes agreement.
How to reconcile it?
Yes, because definition says 2P settlement includes both conciliatory settlement and a direct agreement.
Yes.
Right. But meaning thereby, agreement is also included. But section 30, conspicuously, settlement is not there. It is only word agreement is there.
Yes. Now,
right. And that is why, whether exercising power under Rule 25 to 5A, this man can go beyond the settlement to make an inquiry and to fix another settlement. That is what my query is.
Yes.
Right?
Yes.
So why it is missing? Because otherwise 18C says binding. So Mia Bibi Raji, so kya karega Kaji? So how the Kaji has come?
No.
So Kaji should not be there once it is binding. Right?
Once it is binding, Kaji has no role.
Kaji may not have role or may have role. It is for you to
Yes, yes.
represent.
Now,
Because the word, because
now I have understood.
I have,
Now I have understood.
my view is
Now I have
tentative.
understood your lordship's.
Tentative view is
Tentative
that,
view. I will-
why what agreement is appearing in section 30? Because
Okay,
you have,
let me for that.
you are placing utmost reliance in section 30.
Not only that, rule
No, you are placing one of your limb of argument.
Yes, yes.
Right? So
45.
to 45. So why that word settlement is missing? That is what my query is. And I'm not yet fully convinced.
No, that is correct.
Then if it is agreement is also settlement, then the word settlement would have been there. It was not there.
But every settlement is an
Maybe
agreement.
my question is maybe.
No, all that. Your lordship question is to some extent correct. I am not telling that your lordship is fully correct. To some extent correct, why you have not stated settlement here? Why you have preferred to choose only agreement? Why not settlement? But in the rule 25, it is not only contain agreement as well as settlement. So natural question may arise. If it is a case of settlement, then probably this will not apply.
Because 18.3 says again that all who are parties, not only who are parties to a settlement, but others are also included. Right? Then if others are included, why from the instance of others, that Deputy Chief Labor Commissioner can go ahead beyond the settlement
Yes, yes.
and to make inquiry. These are the
Yes,
things
yes.
which are to be
Tentative
which
question.
are to be conciled.
Tentative question.
This is my view.
Now, let me finish first 25, then I will come to rule section 30 of this.
Well,
Now-
let us see section 30 fully.
First, section 30.
Yes, again.
All right.
Otherwise, you will remain
All right.
half done.
All right.
Section 30.
Page 15.
Section 30 of the Act. Yes. Hey,
Milord, section 30.
Ronganil. Yes.
Milord, one thing should be bearing in mind. Section 30 contains a non-obstinate clause. Non-obstinate clause is there. And that is why, Milord, I have refined this thing. The provisions of this act. What is the provision? Section Rule 25A. Provisions of this act shall have effect, notwithstanding anything inconsistent therewith contained in any other law.
This Rule 25 goes from which section? Rule 25 goes from which section?
Section 12.
Okay. Okay, continue. Please.
So, Rule 25 is for the purpose of implementation of Section 12. The provisions of this act shall have effect, notwithstanding anything inconsistent therewith contained any other law. This law is Section 18, subsection 3, at best, of the Industrial Dispute Act. No. Any other law, or in terms of any other law, first thing, or in terms of any agreement or contracts of service or any standing order applicable to the establishment, whether made, before or after commencement of this act. Now, my lord, this will be more fortified, it will be more clarified if we go through the proviso and subsection 2. What is the purport of the section? Provided that. Now, my lord, let us consider there is a settlement and an order passed under the section 25, section 12. Settlement is more beneficial than the order passed under section 12.
I'm at a slightly prior stage. Whether in the existence of a conciliatory settlement, this man can go further ahead
Ah,
to make an inquiry for pay parity.
yes.
That is what I am trying to find out. If
Yes, sir,
is-
that your lordship will not
let
find
us,
in.
let us read the proviso.
No, your lordship, yes, your lordship.
Read again
Yes.
for the timing.
Proviso. Provided that where under such agreement,
Any such agreement.
where under any such agreement maybe includes a settlement also.
I'm not totally agreeable.
Let us reduce the zone of controversy.
Huh.
Let us reduce the enmity between your lordship and me. Let us reduce the enmity.
The point of discord.
Or point of discord, whatever it may be. I will not refer this to. I will not say this much.
God has no enmity with you.
I will not say anything about settlement. Provided that where under any such agreement, contract of service or standing orders, the contract labor employed in any establishment are entitled to benefits in respect of any matter which are more favorable to them than those to which they would be entitled under this act. So if there is a agreement, I am not referring settlement, if there is an agreement and that agreement confers more beneficial output, then that act will not applicable. The contract labor shall be continue to be entitled to the more favorable benefits in respect of the matter, notwithstanding that they receive benefits in respect of the other matters under this act. So if any agreement which gives more beneficial output, then that agreement may be taken into account. It will be applicable. If any agreement which is less beneficial than the action under the section, under the Contract Act, under this Contract Labor Act, then that will be applicable. Now come to subsection 2. Nothing contained in this act shall be construed as preceding as such contract labor from entering into an agreement with the principal employer or the contractor, as the case may be, for granting them a rights or privilege in respect of any matter which is more favorable to them than those of which they would be entitled to under this act. So anything.
Having read it entirely, I find that settlement is not included.
However, if the settlement is beneficial, then it will be applicable.
No. Settlement is not at all included. Subsection 2 says, notwithstanding any agreement, they can enter into a fresh agreement for better benefit with the employer. The settlement is somehow missing from section 30.
Yes, the settlement that was not envisaged.
Not directly incorporated.
Yes.
Right.
Oh, so that is why some sort of confusion.
Because by reading proviso and subsection 2, I am sure that this agreement is the direct agreement. Does not include conciliatory settlement. Because there is a body involved, some statutory body or statutory authority was involved. Right. Here is a case of direct agreement. Yes. There is one point. The provisions of this act shall have effect with a non-withstanding clause.
Yes.
But that is why my question is, I mean,
Yes, yes,
getting
yes.
it. That,
Yes,
yes,
we are
we are
learning
we
by
got-
interaction.
for me, it is learning.
No, for me also it is learning.
So this provision is right.
Hmm.
It may have provisions is okay. So he has gone ahead of the conciliatory settlement at the instance of a labor union. When they ask for more than the conciliatory settlement benefit and had gone for an inquiry or whatever, fact finding inquiry, whatever inquiry under section rule 25 to 5A.
Yes,
Because of a disagreement or alleged disagreement to receive the benefit under the conciliation third settlement by the other labor unions. This labor union, they have
Conciliatory settlement.
Huh.
Let us forget other union.
So he had gone there.
So your lordship's query is that when there is a conciliatory settlement, whether the statutory authority, specifically Deputy Labor Commissioner, can exercise his statutory duties. That is your lordship's anxiety. Because of the fact this word settlement is not incorporated in section
This
30.
is one. So whether he can go ahead because of the provision contained in section 18(3) also.
Yes, yes.
Right. That is done at the presence and intervention of a statutory authority. So thereafter, it is made applicable to others also. So notwithstanding that, whether he can go ahead under a proviso to rule 25 to 5A.
Which is meant for enforcement of section 12 of the
Right.
Contract Law.
And next, and okay, if it is yes, secondly, the manner.
Yes, yes.
Next, it will be the manner. Manner in which he had done the process.
Yes, if the manner is not correct, then definitely,
Maybe
it will be quashed.
that may
Or
be
quashed
to
proceed
afresh. To proceed afresh.
To proceed afresh.
Right. But if the block is at the first query, then it is prohibited.
Yes, yes.
At the first stage. But if the first stage is okay, second stage will be the decision making or process or fact finding exercise or whatever, pay parity. He had gone ahead by visiting and recording statements of 8+8 and decide the matter and fixing some figure, putting some figure here and there for category 1, 2, and 3, something like that.
That is not very material.
No, he has picked up some figure and put it. Right.
That is their query is that it is not based on any reason.
Maybe.
They are, according to them, this is not based on. So their case is specifically that in view of provision contained in section 18(3) of the Industrial Dispute Act, a statutory authority under Contract Labor Regulation and Evaluation Act cannot exercise his jurisdiction as conferred by Rule 25 to 5A. That is their question.
Maybe that is their case. You have rightly put out that above minimum is, then is fixed by settlement, thereafter conciliatory settlement. Whether all those are binding or not.
So their case is that.
Looks like that.
Looks that. So in order to repeal that contention, I have relied on two provisions.
30.
First is Rule 25.
Rule 25.
Now, before going to Rule 25, what is my contention? The Rule 25 prescribes 3 modes of fixation of wages. One is by Minimum Wages Act. Second is by agreement. Third is when there is, where there is a contract laborer performs same or similar nature of job, then it will be of defined thing. Now, again, in order to fortify my contention, I have referred it. And now it appears me, there is no hurry here. Or.
Rule 25.
Rule 25. 5A. Rule 25. Rule 25, 2, clause 4. Rule 25, clause 2, subclause 4. The rate of wages payable to the workman by the contractor shall not be less than the rate prescribed under Minimum Wages Act. It is very much clear. It is nobody's case also. For such employment, where the applicable, where the rates have been fixed by, where the rate have been fixed by agreement, settlement includes conciliatory settlement, or award. You see, below award is more than conciliatory settlement.
Now there again, agreement and settlement, 2 words.
2 words, agreement, settlement, or award.
Award is different.
Award is more than settlement.
After conciliation of, even if.
No,
it is-
award is defined means when there is a failure of conciliation.
Right.
Then
That
it
I
will
have
be
seen.
then it will be referred to the court.
Court.
Court will pass an award.
That is award.
That is award.
That is award.
That is award.
So here again, use of 3 words.
3 words.
Agreement,
Agreement, settlement,
settlement,
or award.
right.
All right. Now, agreement, settlement, or award, or by the appropriate government, less than the rates so fixed. All right. Again, semicolon, there is a semicolon, you see. Clause 5. In case, if these are the cases, general cases, where the work performed by the contract laborer are not same and similar, then all these things will be applicable.
In cases.
In case where the workman employed by the contractor, we must very minutely read the words between the lines. In case where the workman employed by the contractor perform the same or similar kind of work as the workman directly employed by the principal employer of the establishment, the wage, rates, holidays, hours of work, and other condition of service of the workman of the contractor shall be the same as applicable to the workman directly employed by the principal employer of the establishment on the same and similar kind of work. Now there is a proviso. Provided that in case any disagreement, it is up to the, if there is a similar work, it is the duty of the contractor to provide similar wages. Automatically, despite having this settlement, etc., etc. Provided that in case of any disagreement, in case of only in disagreement, otherwise it will be automatic, despite having settlement, etc., etc. Provided that in case of any disagreement with regard to the type of work, the same shall be decided by the Deputy Labour Commissioner, Central. In other cases, wage, rates, holidays, hours of work, and the condition of service of the workman of the contractor shall be such as may be specified in this behalf by the Deputy Chief Labour Commissioner. So Deputy Chief Labor Commissioner is the authority who would fix the wages. And while fixing the wages, he must take into account that it must not be less than minimum wages. And it may be guided by the settlement award or an agreement. These things. But this is a special case as contained in clause 5 subclause A. So 25 clause 2 subclause 5A. That is a special case. In case where the workmen employed by the contractor perform the same or similar kind of work, this much. Now, what is their contention? Their contention is that if there is a conciliatory settlement, then this clause 5A will not come in force. That is their understanding. That at least I am not in a position to concede with this feeling. And it is up to your lordship. So in order to fortify this thing, Lord, I have just simply referred. Whatever may be, the only thing is that if he has no jurisdiction to exercise his power under 5A for having a conciliatory settlement, then my case will be defined. That is their case. So he has no jurisdiction whatsoever because of the conciliatory settlement. More so, there is a provision under section 18(3). And there is a provision under section RT, which is non-obstinate clause.
Otherwise, read section 12 of the Contract Labor Act and Rule 25. This is regarding terms and conditions of a license.
Yes.
So for that purpose, why this kind of inquiry is required?
The inquiry is required.
Because he knows that rate of wage payable is minimum than above minimum and also governed by a settlement. That is also better than minimum wage.
If it is there, if there is a settlement.
There is a settlement.
Only thing is that.
And whether these are applicable to your union or not, that is one issue.
One issue.
But otherwise there is an SS settlement, conciliatory settlement. Then why he is going inside beyond that? He has to satisfy first minimum wage, okay.
Okay.
Settlement, conciliatory settlement, okay, there. It is above the minimum wage, okay, done. Okay. No award is existing, okay. Now why he is going into same or similar kind of work? Why he is poking his nose?
He poked his nose there.
Where?
That is the crux of the problem. Because of the fact we approached before him.
The then question is, if you are a union, represent the cause of the union, first issue is to be seen whether this conciliatory settlement is applicable to you or not. Next, even if it is applicable.
No, let us.
I am trying to find out. I am open with all.
No, let me go. Consider everything is against me.
No, nothing is against you. Our question is to answer the question. Even if suppose this conciliatory statement or settlement is applicable, but then also you can raise the issue before the Deputy Chief Labor Commissioner. Look, under the conciliatory settlement, something has been given to us, but we do similar or same nature of work.
I have some problem. I have to sit somewhere.
Oh, sure. But so you inquire into it.
Yes. Now we have, to some extent, we have proceeded.
Right.
Yes.
Then he has the jurisdiction to inquire into it.
Well, now only question that is to be resolved, whether when there is a settlement, conciliatory settlement, which fixes the wages of the contract laborer, whether the contract laborer raise their claim that as we are performing same and similar nature of job, we are entitled to have this thing. That is the problem. That is this single issue. There is a settlement which fixes our scale of pay. despite having this agreement, whether we can raise this issue that we are entitled to have equal wages as being paid to the principal employee.
When your union was registered?
In the year 1950. 2015.
2015. You did not take part in the conciliation.
Not
Then-
a recognized union. Lordship.
Huh?
That is not a recognized union.
I don't find-
Recognition
I
or,
don't know why these things will happen.
recognition,
Because
how many,
the-
how many? How many gets recognition?
That-
Whether does it matter?
No, I don't think that.
Does it affect? So does it affect?
No. This is the irrelevant thing. One thing is that there is no settlement with us. And one thing is that there is a conciliatory settlement is a party.
Right.
But so why this thing recognized and all that? And one thing is that in view of section 18.3, it is binding on us. Now, whether this non-obstinate clause as contained in section 18 in the Industrial Dispute Act will be overridden by the non-obstinate clause as contained in section 30. This is the problem. If there is conflict between section 18.3 of the Industrial Dispute Act and between section 31 of the Contract Labor Regulation and Regulation Act. When there is a conflict, which one will prevail?
Whether they were summoned,
No.
Mr. Kolta?
He is inviting his own trouble
No,
by
I-
referring all these things. Please sit down. This is not that it is summoning. All right.
First agreement was executed 2010 Lord, and second 2013.
Settlement.
Thereafter agreement.
Settlement or?
Settlement.
Settlement,
Settlement.
conciliatory settlement,
Consolidation 2010 and 2013.
13.
And
And they exist
Union 2015.
15. The other one, in the other repetition, they
Other
came
It is
because
same logic.
as a trade union, they came into being in 2015.
Yes.
That is an admitted fact. So we'll proceed further to hear you. Because it is also a learning curve for me.
no, it's also learning from me, learning to me also, because yesterday night I was very much convinced that this is my case. I will go by referring this. Now I am to some extent in trouble by the question put forward by your lordship.
Maybe a very innocuous question.
No, it had some relevance.
It's big, but question is that
No, even I
it
could have
will-
proceeded without referring.
it
I
will
could-
not only affect one person,
No,
it will
even
affect
I
a
could have,
large number of persons.
I could have proceeded without referring section 30,
Huh.
but probably I have invited my own trouble.
Okay.
Yeah.
We'll proceed from the stage on the next date.
All right.
When you will be available?
Any day.
On list condition. That is why it took so many days earlier also. এখন ন? আজি হল? হয়। 6 ন? In March. Oh. This is an interview.
Any date except 12.
12.
আজি কি বার?
19? 19?
I will clarify on that date.
Huh?
I will be.
Just
I'll be-
clarify all, just the interrelations.
Yes, 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 I have understood. And yeah, this question has also clarified me to some extent. I have been fortified.
So just the interrelation.
Yes, yes, that I have understood. There is a difference between agreement and settlement.
Looks like.
Looks like. All right.
Otherwise, legislature is deemed to have put the word consciously.
All right.
Mr. K. Kolita, learned counsel for the petitioners is present. Mr. A. Dasgupta, learned senior counsel, listed by Mr. And Miss A. Gayon, learned central government counsel for the respondent Union of India are present. Mr. and Miss R. Who was with BD Das? Miss R. Debbie or Deka. Deka. Learned counsel for the petition in next second item too.
Respondent 3.
In WBC number 2086. 86. Respondent number 3. Huh? In WBC number 2086 2020 are present. Mr. A. Dasgupta, learned senior counsel, listed by Mr. D. Sutia. For the respondent number 3 in WBC number 8150 2017 has advanced his submissions. Most of as the submissions are not complete, release the case again on 19/3/2026.
Interim
The interim order passed earlier shall continue till then.
Hello.
For further hearing, for further.